Jan Conacy.
Fred Townsend, Board Attorney.
Edie Heron.
Rick Perry.
And Barry Brandt. Everyone's present. Okay, Marco, our rules require that owners of properties within 200 feet of the properties in question are notified of the variance. Has everyone been properly notified?
Thank you, Mr. Chair. On behalf of the City Secretary, the agenda for the Board of Adjustment regular meeting was posted in City Hall and on the city portal on June 11th, 2025, and was amended and reposted on June 13th, 2025. The public notice for case number 0425-05 for the property located at 17 Lake Avenue was posted in City Hall and on the city portal on May 28th, 2025. The public notice was published in the Cape Gazette on June 3rd, 2025, and June 6th, 2025, and Delaware State News on May 30th, 2025, and June 4th, 2025. Notification specific to this case was mailed out to property owners, property owner addresses within 200 feet of the subject property, and signage was posted on the property. The public notice for case number 0525-06 for the property located at 330 Rehoboth Avenue was posted in City Hall and on the city portal on May 28th, 2025. The public notice was published in the Cape Gazette on June 3rd, 2025, and June 6th, 2025, and Delaware State News on May 30th, 2025, and June 4th, 2025. Notification to this specific case was mailed out to property owners within 200 feet of the subject property, and signage was posted on the property. The public notice for case number 0525-07 for the property located at 69 Oak Avenue was posted in City Hall and on the city portal on May 28th, 2025. The public notice was published in the Cape Gazette on June 3rd, 2025, and June 6th, 2025, and Delaware State News on May 30th, 2025, and June 4th, 2025. Notification specific to this case was mailed out to property owner addresses within 200 feet of the subject property, and signage was posted on the property.
Thank you, Marco. And I know we did receive correspondence on these cases. Has any late breaking this morning, any late emails come in or correspondence?
No correspondence.
Okay, thank you. All right, did everyone on the board get a chance to review the letters that were submitted by the public?
Yes.
Okay,
Yes.
thank you. Thank you. All right, I know we have a notice of decision to approve that we've been approving. Did everyone get a chance, on the board, get a chance to look at it and sign it?
Yes.
Yes.
Okay, we're good there. All right, thank you. And I know we have one minutes to approve from April 28th, and I was made aware of one correction that I've told Marco on that. I guess the words were transposed, Atlantic Crown Hotel and Atlantic Sands, and I made that correction to Marco. He's got that. Are there any other comments on the minutes?
No, the reason why we didn't approve it last time was because there was a measurement that we wanted to clarify, and Marco did that and sent it out in the meantime, and it looked fine.
Okay. So can I get a motion to approve the minutes of April 28th?
I so move.
Second.
All right, all in favor?
Aye.
Aye. All right, so moved. Okay,
Then we have another one.
we have another minute that came in. I did not get that from Ann.
Yeah. On here, it says October 16th and April 28th. It was in the second, it was in her agenda that we got on the 13th.
I did not get a chance to see that.
We can just hold
Can we hold that till next time?
Sure.
Okay, thank you. Sorry about that.
So we did October 16th. That's correct? Just now?
No, this one was
Oh.
April
Oh,
20th. This one
okay.
was April 28th.
Then I misspoke a few minutes ago. I was talking about the October 16th, which we held from last time because of the measurement issue.
Oh, okay. So yeah.
That, I
Yeah, so
misunderstood.
I'm okay with that as long as Marco made the correction, then I'm okay with approving the October 16th one. So I did review it previously. Okay, make a motion for October 16th.
So moved.
All right.
Second.
All in favor?
Aye.
Okay, so both October 16th, Marco, and April 28th are approved.
Yeah, and they were listed in approval of minutes.
Okay, thank you.
Sure.
I see that now on the agenda. Okay. Okay, that took care of our old business, and we have new business. Go ahead, Jan.
Yes, I'd like to
see if it's okay with the Board of Adjustment. If we move the 69 Oak Avenue up to First, it's probably less complicated than the other two that we're going to be reviewing today. So I would make a motion that we move it to, we do it first.
Okay.
And then,
So you've made the motion, seconded?
Second.
Okay, and on this one, Jan, I will ask for the applicants if there's any problem with changing this order with the applicants and with their lawyers.
So I did ask the parties, at least the gentleman representing the initial applicant on the agenda, and they did not object to being bumped.
Okay, thank you. So,
Is there any reason that we shouldn't consider doing this? That's my discussion
If there
point
was an,
after the
if there was
motion.
an objection and we were concerned about people anticipating that this would be third and they might not be here to, I mean, I don't think that would be a valid reason to challenge the decision, because once the meeting begins, you need to be present regardless of where your item is on the agenda.
Right.
okay. So, all in favor of changing the agenda item?
aye.
Yeah, okay, so moved. Okay, today we have 3 cases to hear. Each case is different, as we have one area variance, one use case variance, and appeal of the building inspector's decision. 2 of today's cases involve a request for relief of city zoning code through a variance. The remaining case is an appeal of the city building inspector's decision, which is allowable under city code. The board will apply the quick check factors that Delaware law recognizes as guidance for boards of adjustments and hear the case made for the appeal of a building inspector's decision. Pursuant to Section 270-74 of the City Zoning Code, the Board of Adjustment is authorized to grant variances that are not contrary to public interest if a literal interpretation of a code or regulation will result in an exceptional practical difficulty to the owner, so that the spirit of the zoning ordinance is observed, provided that such relief may be granted without substantially impairing the intent of the code. Under Delaware law, an applicant for an area variance must prove that the zoning requirements create an exceptional practical difficulty. To determine whether an exceptional practical difficulty exists, the board must weigh the following 4 factors. Number 1, the nature of the zone where the property lies. 2, the character and use of the immediate vicinity. 3, whether removal of the restriction on the applicant's property would seriously affect the neighboring properties and their uses. And finally, number 4, whether failure to remove the restrictions would create an exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This standard is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Everyone who chooses to speak today will be required to give their testimony under oath. I will ask our counsel, Mr. Townsend, to administer these oaths. We do not have a court reporter, so if a transcript is ever needed for this meeting, the city secretary will have to work from recording. So please keep your voices up, speak directly into the microphone, no cross conversations, please. And if any time someone's having trouble hearing, we'll just raise your hand, stop, and we'll correct it and we'll get it fixed. Is there anyone here today who wishes to speak for or against any of these cases? Just raise your hand. Okay, at the time, you'll be sworn in. We limit public commentary to 5 minutes or less. Please observe that rule. And after the applicants and the public finish speaking, we close the public portion of the meeting, and then we start deliberating amongst ourselves, the board. No further public comments will be heard unless the board specifically has a question for someone. And before I get started, I want to let the public know that the board members occasionally will use electronic devices. They are not communicating with anyone on the outside. They're just looking at drawings. Some of these drawings are very, very old or hard to read, so you'll see them zooming in or zooming out on diagrams, and we really appreciate when we get them up here on the screen. So, all right, so let's move on to our first case, which is going to be 69 Oak Avenue, and I'm going to turn it over to Corey to kick us off.
Thank you, Mr. Chairman. Before I begin using these big screens, I'm going to pull up Building Inspector Exhibit A, which is a survey of the property, so that everyone has something to look at while I read the report.
Thank you.
Corey, is that A1 or is that your A1 or is that your A2?
Or 69 Oak. This should be Exhibit just A. One moment here.
There it is.
Oh, you were Building Inspector A, and then there's an A1 and an A2 in addition. But somewhere.
I'll leave it just here, and let me see if I can zoom in.
Zooming would be great. Thank you.
Yeah,
That's the A1, I think. Yeah.
well, this is A. then.
Great.
That's what he's got
Okay.
A, his Building Inspector A, but then we've got A1 and A2 from Jurens Ingalls residence.
I might have to be doing a little back and forth today.
Sorry you have to do that.
So good afternoon, everyone. This is case number 0525-07 for 69 Oak Avenue. The applicants are the property owners, Kevin Jurens and Dottie Ingalls. They are represented today by Bill Feeney, architect, and they are seeking a relief from the following under the 270-4 zoning definitions, primarily accessory building, which states a building subordinate to the main building on a lot and used for purposes customarily incidental to those of the main building or a structure which does not share a wall in common with the main building. No accessory building can exceed 12 feet in height, and that's what they're here for today. They are seeking to allow for the construction of a new accessory building that exceeds 12 feet in height as measured from a point where the center line of the building to be erected intersects with the center line of the street on which the building will front. The proposed height of the building is 12 feet, 3.5 inches as measured from grade. The proposed location of the accessory building is shown to be on the northerly portion of the property. Both the proposed height and location are depicted on sheet A2, titled Site Plan, submitted by the applicant. The current property is located at 69 Oak Avenue and is situated in the R1 residential district. The property is irregular in size, and BI Exhibit A, shown up on the screen here, shows the property contains approximately 12,416 square feet. In addition, just for your consideration, BI Exhibit B is from November 15th, 2024, which includes correspondence between the applicant and myself that led to the applicant seeking a variance. The applicant seeks relief from the definition of accessory building to allow, again, for the construction of an accessory building that exceeds 12 feet in height as measured from the center line of road. The reference to the center line of the street is taken from City Zoning Code Section 270-20, Height Regulations, Note 3. The BI Exhibit B shows the elevation grade of the street to be approximately 18 feet. And I need to rephrase that. That's BI Exhibit A, it should read, which shows a spot grade on the survey. There are small numbers, normally to the 10th decimal, that show spot grade elevations. Shows the elevation grade of the street to be approximately 18 feet, and the spot grade where the accessory building is proposed to be between 21.7 and 22 feet. This is a change in elevation between 3.7 and 4 feet. If taken from center line of road and using the spot grading provided, the accessory building could have a maximum height of between 8 and 8.3 feet. The proposed height of the building is 12 feet, 3.5 inches. So just to be clear, that would be a variance request in terms of feet elevation as measured from center line of road to be between 4 and 4.3 feet, or 4 and 3.5 inches, 4 feet, 3.5 inches. To conclude, this variance request seeks relief from the height restriction of accessory buildings as regulated in the city zoning code under the definition section. The reference point used in determining the height of the accessory building comes from the city zoning code under the height regulation section. Natural grading of the existing property is cited as the main argument for hardship.
Thank you, Corey. Go ahead, Jan.
Okay, I have a question. So typically, a shed accessory building would be 12 feet high. Is that the maximum height the city allows?
Per the, correct.
Yeah, right, okay. I mean, I'm very familiar with the property because I live about 3 blocks down Oak Avenue from it. And I know we all live in Delaware, and it's kind of like on a Delaware hill, it's not, flat, which makes it, to me, very difficult to meet the code because of the topography of the land right there. Most of the houses are flat, they're equal to the road, but that's not. It's a literal hill. We don't see many of those here, but it is. So that was my concern. So it's not really going to be, if the road wasn't, if the house, if the lot wasn't the way it was, then they're really not going higher than they could be if it was like, at my house.
So was that your question, Jan, or?
That was my question. Is it they're only asking 3.5 inches higher than what would normally be allowed? This is my question. What would normally be allowed in a house that was not sitting on a hill? Is that?
Correct. From there, and I'll let the applicant explain a little bit more, but from their drawing on their exhibit, if we took it from grade and just in a hypothetical said that the center line of the street was the same as the grade, they're asking for 3.5 inches.
Okay, that's what I understand. Thank
Okay.
you.
Thank you.
I have questions, as always.
Okay, for Corey?
Yes, yes, please. So this request started out as a garage request, is that correct? Or initially, was that something I read, or did I misread
That was in the
something?
correspondence.
Oh.
And we do have a separate definition for private garage.
Right, right.
And that takes measurements from grade, but there are requirements to be met for a private
Right.
garage versus
I
just
saw
an
those.
accessory building.
So that was never a formal request, that was just a discussion point
That was a
between you and
discussion.
the applicants?
Correct.
Okay. So what is the standard interior height of a shed? Is there a standard? You're talking 12 feet and you're talking at the apex, is that correct?
Well, correct, to the ridge line of the roof.
The exterior apex,
Correct.
okay. Yes, and so but obviously that's not the interior height.
So I did
what's
want
the
to bring
normal-
up, I didn't include it in the report. I did check the numbers, though, for floor area ratio. That's a good point. Normally, people in the past, prior to the basement ordinance taking effect, kept accessory buildings at a wall height of less than 6 feet 6 inches so that the accessory building wasn't factored into FAR. Even if they built this accessory building beyond and what would normally be included in floor area ratio, the size of the house versus the size of the lot, the size of the building that they're showing here in no way impacts the floor area ratio.
Okay.
That would encroach over our allowed.
You've anticipated my next question. So other than the height, is there any other aspect of the building or the lot that doesn't meet code? And I think you just answered that clearly, correct? Okay. So to verify, if we should grant the variance, essentially that we're granting 12 foot 3.5 inches rather than 12 feet as the exterior apex of the shed.
If we were to use their exhibit as a building permit, correct.
Okay. But otherwise, if we don't grant the variance, then they're limited to 8 feet to 8.36 as the apex. But that would allow 6 feet 6 inches interior, wouldn't it?
Correct.
So they could meet they could perhaps meet their, and I can ask the applicant, their request or their needs with a shed within code. If they decided to, is this correct? That if they made it shorter, if they made it 12 feet?
Well,
I think 8 feet.
8 feet, yeah. It would have
Well-
to be less than 12 feet.
The
right, I'm
maximum
sorry.
height for my report shows if we were to take the measurement, the reference plane as the center line of road, the max to the peak of the shed or the accessory building would be just around 8 feet, a little bit more. Yeah,
8.36
8 feet
or
and a
something
couple
like that.
inches.
But then how much does, in standard construction, how much does that leave clear inside? At the interior?
With the new ordinance that we have now, it would be 6 feet 8 inches. They have 2 inches there. And then so that gets them to the top of the wall. That's not factoring in foundation height or
Okay.
anything like that, because you want these sheds to be raised off the ground some. I would maybe ask that of the applicant if they could.
Yes, I plan to ask
But-
the applicant.
Is it within math? Yes.
Okay. Have you received other requests similar to this that have, where people need, because of the grade of their lot, that they are not able to build a shed that would otherwise meet code?
No, not typically. Most of the lots here are either flat or they go down when there's a body of water behind them.
Okay.
We had one, Edie.
we
had
did have
down-
one.
I
down
thought
here
we did.
Near Silver Lake, the house on the corner of Silver Lake opposite Jay's house.
Right.
And that was a.
Right.
The road, it was measured, question was it going to measure the front or the side of the house? And given what the address was, they ended up.
It was on the corner,
that issue.
right?
Right, yes.
You're right.
And it
Now I
was on a-
recall.
It was in a flood zone
I
also.
re- I remember.
I believe we turned.
Let's see. That's all that I have for you. Thank you very much, Corey.
Thank you, Edie.
Could I clarify one quick thing? I think
course.
Mr. Shinko was asked what would be a typical height for the inside
Yeah.
of an accessory building, and then he answered, well, when FAR comes into play, you often see the height of the interior to be limited to 6'6", and now maybe 6'8",
6'8".
but that wasn't, I don't think that was exactly what you were asking. So 6'6", 6'8" may not be the standard interior height for an accessory structure, and maybe you're not in position to say, well, this is the standard height of an interior of an accessory structure. That's all. I didn't want there to be an impression that every accessory structure we see is either 6'8" or 6'6", because that's an artificial
Right. Measurement.
number that's produced by our FAR ordinance.
Would you say in more clear answer to my question, and Fred's right, that is what I was asking, is there, a shed is usually at least this and no more than that in this window of X to Y, interior? Oh, sorry.
That may be a hard
And
question.
the only thing I can give is a lower and upper limit.
Okay.
FAR increases by double if the wall plate exceeds 12 feet in height.
Right.
And then a standard room per building code in residential uses is 7 feet. So while you can go down to 6'8" because it's non-habitable, I would say a lower limit would be 6'8", and an upper limit would be 11 feet, 11
Okay.
inches.
That's great. That really answers the question. And thanks, Fred, for helping us clarify that. That's all I have.
Thank you, Edie and Fred. Any other questions for the building inspector?
Carly, can you explain what you understand the rationale is that if this were a garage, it's measured from grade, but if it's an accessory building, it's measured from center line? I'm trying to rack my brain to figure out what the reason for that is. Do you have any idea?
No, that's on the agenda for code revisions.
We did not set each other up for that.
I have looked into that, and I haven't found a simple answer. For some reason, private garage, they built it into the definitions to stand alone and apart from every other height regulation that's determined by 270-20 in our zoning code.
So if this were a garage, just in terms of the effect on neighbors or driving by, if it was a garage, it could be 12 feet from grade because it's a accessory building, it's measured 12 feet from center line.
That's in the correspondence, BI Exhibit B, where those definitions are both given. But the private garage allows no more than 12 feet as measured from the grade, and then the peak of the height of the roof can be no more than 6 feet above the eaves, which would be your soffit or something like that.
All right, I just wanted to make sure I understood that. Thank you.
Okay, at this time, I'd like to ask Mr. Feeney to come up and speak. And Mr. Townsend will swear you in.
So, Mr. Feeney, we'll begin with, just for the record, give us your address, please.
Just pull it down. There you go. Thank you.
Do I push it when I talk?
Nope, you're good.
So full name, please, and address.
William L. Feeney, 4519 Chesapeake Street, Northwest Washington, D.C., 20016.
Very good. Mr. Feeney, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes.
All right,
So
do you have
you can proceed.
presentation for us, or?
Everyone has the packet, I assume, right?
You want to get closer to the mic, please?
Yeah, yeah, pull the mic a little bit
Sir,
closer.
we can't really hear you. Your mic needs to be real close to your mouth. It's hard, I know. We have to remember the same thing.
Corey, if you could
Hi,
just show me A2, I think that's the key.
Mr. Feeney, this will pull towards you. It will pull toward, the whole thing will pull
The whole
towards you.
unit. There you go.
There you go.
Thank you.
Sorry, I'm very sorry.
It's not just that. We need to make a recording as well.
No, I understand.
Okay. Is that the diagram you want? Okay, please proceed.
Okay, just to clarify the situation, a lot having to do with the questions you had. Basically, the street is 4 feet, a little bit more than 4 feet below the grade where we want to build the shed. The shed has to be built 10 feet behind the existing house, so we put it back in the back corner of the lot. So right off the bat, you were asking about how high it might be, but if it can only be 12 feet from the center of the street, and I've already lost 4 feet in grade, that means it's 8 feet to the ridge, which means the building itself would be about 4 feet. So I could probably slide canoes in there, but that's about it. So it's not, I guess I want to point out that it's not, we're not asking for something exorbitant. It's basically a shed, but because of the grade, it's just elevated, and that's why we need relief from elevation.
Okay, thank you. At this point, I'm going to ask if anyone on the board has questions for Mr. Feeney.
No. Rick does, and I do too.
Okay, Mr. Perry?
Mr. Feeney, can you give us an idea of the topography of the adjacent lot to the rear and side, adjacent lots to the rear and side of that property? Is the topography there, are those lots lower, or are they at that point the same grade?
They're all at the same grade. There are some photographs that I submitted with showing pictures of the back corner, but all the houses behind us on Park is at that height, and I actually think they're flat from back to front. And then on the side, the east side, the ocean side, her lot does exactly what ours does, and on the west side, their lot does close to what ours does, but everything slopes downhill towards Oak on the Oak Street side, and then on the Park side, it's all, there are no retaining walls or anything.
Okay, thank you.
Thank you. Edie, any questions?
Yes. Did you explore any other options with your clients when you found out at first that this was going to violate code or it could, and that you'd need to seek a variance to be able to build what you wanted? Did you look at other options either with them and/or with Corey?
We did talk, I had multiple conversations with Corey and with the owners, and we originally did talk about possibly putting a garage in there instead. But we just realized that we don't really need that kind of space. We just need a space to put kayaks and bicycles, and the restriction is it's gotta be 10 feet behind the house.
Right.
So the best I could do would be to move it forward probably 8 more feet, which means I'd still need a variance, because the ground just gently slopes. So there wasn't really another alternative to creating this thing, and I can't attach it to the house.
Right.
So it had to be floating in the yard somewhere.
Okay, thank you. Jan, any questions?
No.
Bill, any questions?
No.
And I do not have any questions for Mr. Feeney.
Want a motion?
Now I want to see if public.
Oh, I'm sorry.
Well, we also need to make sure we don't have others in the room who wish
Right.
That's right.
to speak. And then you've submitted some pictures. Is there anything you want to say about what these pictures show? Or maybe it's obvious to the board?
I didn't understand why we had the pictures.
That's why I'm
They
asking.
Well,
were,
the submission requires pictures.
Right,
right.
right. It does require pictures, but is there anything you want to add?
I think it was just to explain the conditions. I took some near shots so you could see the surrounding properties, and I took some far away shots so you could get a sense of how the hill goes up. So I just wanted to try and explain the situation. If there are questions about the pictures, I could go through those.
No.
There doesn't seem to
Yeah,
be.
there doesn't seem to be any questions. That's why I wanted to go to the point. Is there anyone from the public who wishes to speak for this case?
One more thing. You indicated that 4 feet, an accessory building that gave you 4 feet of head space or wall space would be inadequate, right? That's your
Well, the
testimony.
wall height would be 4 feet, and then the roof.
Right, I know it seems obvious to you, but I want
Okay.
to get something on the record.
Yes.
So the additional 4 feet is required. Why? Would that be the minimum that would be required in order to address your concerns, or could you get by with less, or?
Well, but I think what our approach was that if this were a flat lot and we built an accessory building, it would be a 12-foot high thing. So what we wanted to say is, we would just like to build the normal thing, and then the topography actually changes its elevation from street. So that's why I'm saying we're not asking for something bigger than we could get with a flat lot, basically.
So you want the normal amount of ceiling height?
Yeah, I mean, because of an overhead door and just walking in there, the idea of ducking to get into this thing just seems hard.
Would it impact the usability of the structure if it was restricted to 4 feet above grade?
It would, yeah, I think it would completely change the situation, because a bicycle is, 3 feet, and you'd have to crawl in, and then we couldn't have any wall space to put ladders or anything. It would just be all low, like I don't.
So you want to utilize the walls some, and I'm saying you, but your client wants to utilize the walls for storage as well, like in a typical
Yeah,
accessory building, obviously.
the inside. I mean, we're not going to store things on the outside, but I'd probably put an extension ladder so that it could be above bicycles, because I don't need the extension ladder very often, but bicycles I need it. So it's just usability. I mean, going to the trouble to build this thing and building it only 4 feet tall just seems, I don't want to say wasteful, but not very efficient.
Thank you. Fred, you good?
One more.
Go ahead, Rick.
Mr. Feeney, you mentioned that the intent was to use this as accessory building for kayaks and bicycles. If that is the case, I'm assuming, just knowing kayaks are usually stored, up on walls. Is that the intent that your client has here?
Well, like I said, we're going to utilize the wall space so that we can maximize the storage. So kayaks will probably be put on walls, supboards, that kind of thing, extension ladders, and then bicycles will be on the ground. And so we wouldn't have the kayaks on the ground next to the bicycle. I mean, it's just efficiency.
Everyone good? All right, ask the public again. Is there anyone from the public who wishes to speak for or against this? Okay, at this point, I'm going to close down our public commentary, and the board will discuss this. I'll start off. This is the first time I've ever had a case where I did not have any questions. I looked at it, and I kept thinking to myself, if we ask these applicants to drop down the peak, it's going to end up resulting in a very ugly building, so much so that it would impact the neighbors the way that it looked. I feel like in a normal shed at the 12-foot, I know it's 3 inches above, would be more appealing and would blend in more seamlessly with the surrounding neighborhood versus asking them to, I'll be real extreme here, put a flat roof shed on, getting them to duck in. So that's how I feel about this case. It was almost to me like a no-brainer on this one. So I'd like to hear for or against those thoughts.
I have to agree with you, because I know that hill, and so I think there is an exceptional practical difficulty just because of the topography of the land, and
Right.
and the house next to them is up a little bit too, and I mean, there's nothing you can do, and you can't have a 4-foot, I mean, I would kill for a shed, frankly. And I know somebody who's removing part of their house for a shed. So, I see it as
And I agree
as
with
a
you
fine thing.
that the land has created
The
this
land has
exceptional.
created the exceptional practical
the
difficulty.
difficulty.
It isn't certainly the owners of the property.
Correct. Bill, thoughts?
And I'm totally comfortable. It actually seems almost the epitome of why there's a zoning
Why-
variance.
Exactly,
right.
exactly.
Because of the reasons you said.
Right. Edie?
Yeah, I'm in agreement as I look at the quick check factors. The nature of the zone meets it. Character of the immediate vicinity meets it. Removal would the removal of the restriction seriously affect the neighborhood properties? No. And the exceptional practical difficulty, I agree, comes with the land. But I want to make sure that when if we decide to approve this, that we limit the height to Corey's measurement. Because as we know, if we grant a variance, it goes with the land forever.
Right.
No matter who has the land, 100 years from now, next week. And so we don't want to approve just in general a shed of whatever.
You'll end up getting a ski chalet.
Right, or the next person has, okay, they'll go 16
Right.
feet or whatever. I think we want, if we agree that this situation is something we want to approve, then I think we should be very specific about the height that we are approving and go from there.
Good point, Edie. Thank you. Rick?
I agree with what everyone else has said, and Edie clearly indicated that it meets all the quick check standards. Clearly, the problem is inherently in the property, and prohibits the owner from being able to improve the property in a normal manner. What you'd end up with, in my view, without the variance, is something akin to the doghouse my dad built for my dog when I was growing up. So that's not an accessory building. So I'm fine, moving forward.
All right, thank you, Rick. May I get a motion from someone on the
I move that
board?
we approve the request for a variance, limiting the height to 12 feet, 3.5 inches, as requested by the owners, that the variance is an exceptional practical difficulty because of the land and the slope of the land.
I'll second that.
All right. All in favor? I'll start with you, Rick.
Aye.
Based on,
Based on the comments that I made earlier, I think it meets all of the standards of the quick check case, and it's unfortunate that our code doesn't anticipate things such as this. Maybe it should, but I think that this is an appropriate variance to grant.
okay, thank you. Edie?
I vote yes. The quick check factors are met, the first three without even thinking about them. And the fourth one, as we say, the practical difficulty is the land itself. And I think we are limiting it to meet exactly what the applicants have asked for and nothing more, which I think is one of our dictums here as a board.
Thank you. Jan?
Yes,
Based on?
based on the quick check and the exceptional practical difficulty is the slope of the land.
The land. Okay, thank you. Bill?
I agree. I would grant the variance. I believe that they meet all 4 quick check factors.
Thank you. I too also vote yes to grant the variance. All 4 quick check factors are met. The land is the nature of the exceptional practical difficulty, and I agree with Edie's criteria that establishes the height and approve it at that. Where'd Corey go? Yeah, prove it at the height specified. So it's approved. Thank you, sir.
Thank you. Thank you all.
All right, thank you.
And thank you, Corey, for making it
Thank-
so clear for us.
Okay, next case is 17 Lake Avenue. So I'm going to have, this is an appeal of the building inspector's decision. So,
These are neighbors of mine. I was also quite familiar with David Francis and his wife when they were going through all of the issues here, so I believe that I should recuse myself.
Okay, that is your,
Yes.
your decision, okay. All right, so,
So, Mr. Pearlstein, you'll be asked to take a seat in the
yeah,
audience. yeah.
mhm.
And then do you want me to make some?
Yes, please.
Okay. So I'll take this opportunity to remind the board that it is authorized under 270-74. It's empowered to hear and decide appeals where it's alleged that there's an error in any order, requirement, decision, or determination made by the building inspector in the enforcement of this chapter or by any ordinance supplemental hereto. In the course of exercising these powers, this board may reverse or affirm wholly or in part or modify an order, requirement, decision, or determination made by a building official such as the board would like it to be. And in that sense, the board has all the powers that the building inspector has from whom the appeal was taken. And as is the case in an appeal, we often reverse the order of the presentation so that we hear first from the appellant. And the parties have discussed the order of the procedure today, and we're going to hear first from the appellant, the appellant's counsel, and then we'll hear from the city. And then it would be customary for the appellant to have a last word. Generally, the presentations are not restricted to any specific time period. The board, I don't think there's any chance, based on the conversation that took place earlier, that the board might speak up and say, well, we've heard plenty, and we're ready to move on. I don't think that is going to happen, but the board could exercise that jurisdiction. And are there any questions about that from anyone? There's a gentleman in the back who's raised his hand. We're required to, and we have every intention to
Yes.
ask the public, and thank you for reminding me to weigh in on this after the parties. So appellant, city, public, then appellant. That, I think, would be the order. Okay? Anyone else? I presume you might like to be heard as a member of the public. Is that right? Anyone else in the room? Raise your hand. Of course, yeah, you're a party. No other interested parties at the present time. Okay.
Okay, so let's bring up the applicant. Appellant.
Good afternoon, board members, Mr. Townsend. Nicholas Condershoff from Redunda Williams and Condershoff. I am here on behalf of the applicants, the McKays, the current owners of 17 Lake Avenue. I have handouts, if I may approach.
Should we
hand them out.
swear him in?
Well, no,
That-
as a member of the bar,
he's
he's
fine.
beholden to even a higher authority than this one. So we will not require him to
Okay.
swear. But his clients will if they give testimony, as will anyone else who
Okay.
gives testimony other than the city.
I have a question.
So is any of that material it's all been shared with the other side, do you think? Or is
I'm sorry.
the material you would like us to see that you have in your hands there?
Yes, I'd like to hand it out if I
Have
could.
we already received it?
No, you have not.
Has the city received it? Has the city received it? Do they know what you're doing?
These are documents that are in the record. This property has quite a bit of history, and really, it's the notice of this hearing, the building inspector's decision, the court case that affects this property, which typically judicial officers can take judicial notice of. The registration for the property, which was submitted to the city would have it. And also,
So far, that's all
All-
fine.
all
That's
the
all
only-
part of what's in the record.
Correct.
Oh, excuse me. Go on if you want to describe more of what you have there.
yes, I've put it together to make it easier for you to reference during my presentation.
Okay, so there's nothing new that we haven't seen?
No, not at all.
Okay.
Thank you. Have all of this.
Thank you.
Thank you. No. So it looks like we have, well, we've received much, if not all of this. Maybe at the back, the last one. The last, for me at least, I don't know if I, can I say this now? The last several pages after the last green piece are new to me. How about the rest of you? The rest of it is all,
Concur.
Those are new, yeah.
yeah.
So one thing, there was a final order that was issued, I guess, after the decision was handed down. Is that right?
That's correct.
Amended.
So I don't know that that was circulated. Obviously, that's not a problem. I mean, that's,
It's actually in the record, I believe.
it
it
is in the
is.
record?
Yes,
Okay,
it is.
all right, very good.
Both versions are in the record. There's one that's
Yes.
sort of notated and a final one.
Very
I believe
good.
that order is at the end of this case. But I'm really just making general reference to these documents. Do you mind if I stand here?
You may
Speak from
proceed
here?
Any way you're comfortable.
Thank you. Again, Nicholas Kondrashoff.
It is.
I represent the current owners of 17 Lake Avenue, who I'll refer to as the McKays. We are appealing a decision of the building inspector, which was set forth in a letter of the building inspector, which was also then elaborated on or clarified by Mr. Walton. In Mr. Walton's letter to myself dated March 12th, and this appeal was taken on March 22nd. The decisions that we are appealing is where the building inspector allegedly found code violations with respect to the McKay's garage apartment and denied the McKay's request for a rental license. And that letter and Mr. Walton's correspondence instructed the McKays to take an appeal to the board. The McKays seek to rent the second and third floors of their garage apartment together with the main house. This is an important detail. The McKays don't want to rent the garage apartment separate from the main house or rent any floor of the garage apartment separate from any other floor. They want to rent it all together, the main house, garage apartment, second and third floors. As I mentioned, there is some history to this property. In 1987, the former owners, the Francises, reconstructed the existing legal non-conforming garage apartment, which was a second floor apartment above a garage, and an attic, or what the court, as we'll hear later, described as a loft above the second floor. The Francises essentially converted that loft into a third floor and did so without getting a special exception, which was required at the time. Importantly, the city of Rehoboth said in court that it would have given the Francises the special exception had they applied for it. And the third floor living space, the loft that was converted to a third floor living space, did not violate any height restrictions. Now, I mentioned court because in 1991, two neighbors sued the Francises, although one later dropped out of the lawsuit. In the end, the court found that because the Francises didn't apply for the special exception, they could only use one floor of the garage apartment for residential purposes, either the first or second floor, but not the third floor. And the court noted in its decision that the garage apartment, either the first or second floor, could be rented with the main house. In 1992, likely as a result of the court case, The city code was amended to permit owners to register their illegal, non-conforming garage apartments within 60 days. And if so registered, those garage apartments would be or would become legal, non-conforming garage apartments. This is what is known as amnesty legislation. Essentially offers forgiveness for these garage apartments if they're registered within 60 days of the legislation. Again, this legislation, this amnesty legislation, was likely the legislature's response to the court decision. And this is indeed how our government works. If the people, through the legislature, don't like a court decision, legislation can be passed that essentially supersedes the court decision. For instance, if someone is found to be doing something illegal by a court, the legislature can change the law so that that thing is no longer illegal. This is not in dispute, that what the amnesty legislation did.
Is there any legislative history that you're aware of? Any minutes from the meeting in which it was passed, in which that justification was given, or is this just ipso facto a conclusion that you're reaching?
I believe that this is the purpose of the legislation, it being amnesty legislation. It is very difficult to find records going back that far.
Excuse me, Fred, could I just say something?
Go ahead, Jan.
Question for
Yeah,
the
ask it
applicant.
as a question.
I
yeah.
was a city commissioner, and then,
Well, if you have a question for the applicant.
okay, no, then I don't, because
Okay.
what he's saying isn't true.
The former city solicitor acknowledged this, that this legislation basically rendered the court decision moot. That's in correspondence from the city solicitor, the former city solicitor, to the parties at the time. Again, that's not in dispute, and I will get to what's in dispute in a moment. The Francises, under the amnesty legislation, registered their entire third-floor garage apartment, which made the garage apartment a legal, non-conforming use. And the fact that the Francises did that is not in dispute, not by the city or anyone else. Let me just repeat. The Francises registered their entire third-floor, three-floor garage apartment. The dispute is over what the Francises registered as habitable living area, because the former city solicitor said that they only registered one floor as quote-unquote habitable living area. This, I submit to you, is unreasonable. There was no reason for the Francises to register just one floor of the garage apartment under the amnesty legislation that had already been found by the court to be a legal, non-conforming use prior to the amnesty legislation. The Francises didn't need amnesty for just one floor of the apartment.
Well, they would have needed amnesty to rent it separate and apart from the main dwelling, correct?
That's correct, and that is not what the appellants, the McKays, seek to do here today. They don't seek to rent it separate from the main house. They seek to rent it together with the main house, but the second and third floors. But you don't have to take my word for it. You can just look at the registration that was submitted to the city in 1992, and I've got a blown-up version of that, and that's in your materials. This is the registration that the Francises submitted in 1992 under the amnesty legislation and within the 60 days required. And as you can see, it says one dwelling, 3 stories, 1,500 square feet. So again, here, number of dwelling units, 1. Stories, 3. Square footage, 1,500 square feet. And what I'll get to in a moment is floor area devoted to human habitation, 600 square feet. That one dwelling, 3 floors, 1,500 square feet is the entire 3-floor garage apartment. That's what the Francises were registering. In terms of floor area devoted to human habitation, 600 square feet. That's not defined, by the way. Does it mean stairwells? We don't know. The Francises put 600 square feet, which is basically the combined square footage of the second and third floors. They also put 8 plumbing fixtures throughout the second and third floors. You can see those here. Now keep in mind, the Francises aren't experts, and this legislation did not require that experts fill out the forms. It was meant to be filled out by regular, everyday homeowners. But the former city solicitor said, no, 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 no. The second floor, as measured by an expert, is 383 square feet. And the third floor, as measured by an expert, is 317 square feet, which in total is 700 square feet. That's where the surveys at the end of the handout come in.
I don't mean to interrupt, and I rarely do this, but you keep talking about a former solicitor said. Who was that? I don't believe it's in my record.
It's Glenn Mandalis.
Okay. Do we have a copy of that correspondence? Because I don't have it.
That's in the file, in the city's file.
Is that in this, is that
That
in
is-
this
that is
material?
not- that's
Is that
not-
in this material that
It's
you?
not before the board.
No,
That's not, I was provided that by Glenn Mandalis. That was the city's, in the city's file.
Not part of what's presented here.
no, we don't have that.
It's just not
So,
part of the
but
package.
you have something in writing which evidences the legal opinion of the former solicitor. And we-
Absolutely,
And
yes.
we don't have it.
Yes. And quite frankly, it doesn't necessarily matter. But that's kind of the genesis of this dispute. And I suppose it would fall upon the current city solicitor and the board to determine what it was that the Francises registered. I'm not using Mr. Mandalis's opinion for necessarily legal purposes. It's to explain this dispute, part of which has been repeated in the building inspector's finding of violations and denial of rental license, and Mr. Walton's correspondence to me as well, elaborating or clarifying the building inspector's decision. And Mr. Walton could have very well arrived at that conclusion independently.
Fred, may I ask a question?
Of me?
Yes.
Speaking.
Yeah. Mr. Mandalis was not city solicitor in 1991 and 1992, so he's issuing an opinion that I would have been Max Terry or possibly Walt Speakman. I can't remember when that occurred.
Obviously, the applicant is talking about a communication he had with Mr. Mandalis, which would have been years after
Okay.
that period of time.
Oh, okay. All right. I'm just very
But
confused about
I
it.
am concerned that
Right.
you've relied on that and made a point of emphasizing on a couple of occasions that you've had communications with the former city solicitor, and we don't have that before us, which puts us in a position of having to accept hearsay, essentially. Now, you've indicated that it's in the file, but we need it in the record in order to properly evaluate it. So that's a problem we're going to be struggling with. We'll hear from the city shortly on that, I'm sure.
Respectfully, I disagree that it's a problem. Again, it's really part of this story. You don't have to accept it. It is just really the history of this dispute. And it was Mr. Mandalis, this was sometime after the 1991 court case and the 1992 legislation when Mr. Mandalis was city solicitor, and he issued these opinions, which were in a file that he provided to me while he was still the city solicitor. Again, I'm just trying to explain the history of the dispute, and almost as a way of telling the two sides of the story of the dispute. If there is no dispute, then presumably the appeal would be granted and the McKays would be allowed to rent the second and third floors of the garage apartments with the main house. I suspect that Mr. Walton has an opinion on this as well, and it's perhaps the same one. But again, this goes back to 1987 when the Francises built this property. So we're talking decades of history, and there's been, to a certain extent, an impasse within the past few years or decades. And so I believe that the dispute that existed then, that still we think exists today, would be relevant. But again, you don't have to take my word for it. You can look at the registration. I believe you can take notice of this and the fact that it's submitted by the Francises. It lists one dwelling, 3 stories, 1,500 square feet, 600 square feet of habitable area. Quite frankly, I think you can make your decision based on this and this alone.
Is there a signature by the building inspector on this? I do not see, I just see appears to be a vague line, but it can't be a signature, nor is there a date.
I mean, I believe it has a stamp from the city. It certainly has Mr. Francis's signature. This is also in the city's files.
So that is in question whether the building inspector ever saw this, correct?
Well, it's in the file.
As is.
I mean,
Okay.
this was obtained from the file, not from your personal records.
That's
or from
correct.
your client's personal record. Okay. Is there any significance to the fact that accessory building is underlined, and who underlined it? Do you have any idea? In the top paragraph?
That says business.
I don't
business
know,
address.
and I don't know whether
There.
the Mr. Francis who filled this out would have done that, or the building inspector.
Okay.
But as I mentioned, the second floor, as measured by an expert, is 383 square feet. The third floor, as measured by an expert, is 317 square feet. That's 700 total square feet. The city, my understanding is that the city has taken the position that the 600 square feet of floor area devoted to human habitation just refers to one of those floors, which doesn't make sense to me. And I question whether it makes sense to you. How can 600 square feet be just one floor of the garage apartment? The second and third floors are 700 square feet total. The Francises, as non-experts, put 600 square feet habitable living area, which again is not defined. It appears to me to be obvious that the 600 square feet, with all of the plumbing fixtures listed, is referring to the second and third floors. How can one say 600 square feet is only one floor? I believe that's completely unsupportable. and just doesn't make sense. By the way, the city code permits garage apartments to use 51% or less of the total square footage. So the second and third floors at 600 square feet of habitable living area, or 700 square feet total, is permitted by the city code. Which requires that the garage apartments be 51% or use 51% or less of the total square footage, 51% of 1,500 square feet total is 765. So the 600 square feet falls well within that range of what's allowable for a garage apartment. And so we ask the board to set aside the building inspector's decision, which was based on what I submit as an unreasonable interpretation of this registration, alleging that the 600 square feet habitable living area was just one floor, and permit the McKays to rent the second and third floors of the garage apartment together with the main house, which is permitted by the amnesty registration and city code.
May I ask a question? Of the
Certainly.
plumbing items numbered 1 through 8, are any of them on the first floor?
Are they? Some of them, yes. Those, all 8 are the entire first, second, third floor. There are, all of those listed are spread out throughout the first, second, and third floors.
Okay, so then 600 square feet, human habitation would also include the first floor. So I'm not understanding Mr. Francis's, he's not here, his math on the fact that 8 of the plumbing fixtures are across 3 floors, yet a 1,500 square foot structure, but only 600 square feet of those is habitable. Could it have been that he meant to ask for the ground floor? If he's off from 600 to 700 and what'd you say, 14 feet or 18 feet, was he off, if you flip it the other way, that he was saying 600 square feet is just the first floor?
I don't,
Possibly.
I don't believe that's the case.
Okay.
Now, Mr. Francis isn't here. I believe he's deceased. But there is no, what I would consider habitable living area on the first floor. That is essentially a garage and or workshop. The second and third floors are outfitted for or as living area.
Okay, but it has either a kitchen sink, a dishwasher, clothes washer, something of 1 through 8
Correct.
are on the first floor.
Correct.
Okay.
Again, I think he was registering the entire dwelling, 3 stories, 1,500 square feet. But when asked habitable floor area devoted to human habitation, that's the second and third floors. The first floor was not devoted to human habitation.
Okay.
I'm sorry, I'm being corrected by the, there's, the McKays are saying there's no plumbing on the ground floor.
Okay, so 1 through 8 are only on the second and third floor. Okay, thank you. Please continue. I'm sorry.
That was the end.
Okay.
We're asking that this board interpret the registration to mean the entire structure, the three-floor garage apartment, and floor area devoted to human habitation to mean the second and third floors, which are 700 square feet as measured by an expert, but contain those plumbing fixtures, and ask the board to reverse the building inspector's decision, finding violations and denying the McKays a rental license. And we ask that you permit the McKays to rent the second and third floors of the garage apartment with the main house, as permitted by the amnesty legislation with this registration and city code.
Okay.
May I ask a
Thank-
question? Okay, I have a few questions for you. You keep talking about an expert who measured everything. Why didn't that person sign and date these measurements? Where's the signing and dating? How do we know who did this?
And ma'am, that's from the city's file. But again, I don't think,
These that you just gave us?
yes.
Okay,
And again, we're talking about a file that goes back 30, 35 years.
okay. And,
But again, the dispute arises because my understanding is that the city takes the position that when Mr. Francis put 600 square feet, he was referring to one of those floors.
I see.
When those floors, in fact, are 317 square feet and 383 square feet.
Another question, you keep talking about amnesty legislation. We are confronted with this kind of thinking a number of times, and my question is, are you thinking that this amnesty legislation goes on forever? Is that what you understand when you speak to us?
No, not at all. This legislation required that anybody seeking to comply with it or fall under it had 6 months to register these garage apartments.
Right.
And that was it. After
Right.
6 months, no
I understand that, but then what? I'm asking you what your definition of this amnesty is, sir. Once they've applied for it and been given it, how long do you think that goes on?
I believe that would stay with the land.
So you're
Continue with the
considering
land.
it's like a variance. Is that right? I'm trying to understand what you're telling us, what your perception is, sir.
I suppose you could call it a variance. I think perhaps it would be more of a special exception, but it is one that if the homeowners registered during this limited time period, these became legal non-conforming uses, and that continued with the property.
So your feeling is if that happened, that this would go on forever, no matter what happened with the property. Is that what you're understanding, sir?
That's my understanding.
Okay. Should,
Other questions, Edie?
yes.
Yeah, please continue.
Thank you. I'm looking at the cover letter that is part of our information. And you quote the court found that only the first or second floor, not the third floor of the garage apartment could be used for residential purposes, and the garage apartment could not be rented separate. We were all agreeing about the separation. I'm just wondering if you're stating that way in your letter that you submitted to the city on April 28th this year. And it sounds like you are, there might be a disconnect now with the verbal testimony you've just given.
I don't think there is. I hope there isn't. The court found that only one floor could be rented.
Right,
The first or
right.
second floor, together with the main house.
Right.
That was in 1991.
Right.
And then this amnesty legislation came out in 1992, which said that they could register their illegal non-conforming garage apartment within 60 days. Which they did. Again, if they were only going to do one floor, there would have been no point. 'Cause
So it's your position that the Francis, or Mr. Francis, or Mr. and Mrs. Francis, I forget, never brought the property into compliance with the court order? They just continued to make habitable or use as habitable the second and third floors, and that the amnesty legislation allowed them to do more than what the court?
No, not at all. In fact, that the order that you asked about, that was to be entered after the Francises had brought the structure into compliance, which they did, and the court signed off on. But then this amnesty legislation came out.
But isn't the nature of amnesty legislation that what you've been doing may be done in the future in perpetuity under this concept of amnesty? But you seem to be suggesting that it was an opening of a door that allowed them to go beyond what they were permitted or what they were doing in terms of using that accessory building as habitable. Are you saying that because of this legislation, they were allowed to make habitable a second story in that building that wasn't permitted to be habitable.
I believe that's correct, and that was, I don't think that's in dispute. I don't think the city takes the position that anything else is the case. My understanding is the city agrees that that legislation mooted the court case, and the Francis's registration under this legislation mooted the court case.
So I have a question along that. Maybe Fred, you can help me answer. So the court found it in violation. The court the Chancery Court gave a directive. And a piece of paper from the city of Rehoboth Beach is supposed to override the state of Delaware. I think the intent of the Chancery Court was clear. Take it out. You know, just take it out and it doesn't come back. But now along comes a paper from the city of Rehoboth Beach that says, okay, if you register, all is forgiven. I have a hard time understanding how the city of Rehoboth Beach can override the state of Delaware in this condition. And Fred, if you can help me explain to me that's common?
Well, I mean, I think the council could, if it chooses to, and which boils down to this issue of whether, you know, what was the intent of that legislation. If council were to say in the process of adopting that legislation that this is in response, in part, to a problem that we had at this address, and that with the adoption of this ordinance, the Francis property could be inhabited at the second and third floors, then it would be crystal clear. I don't think the city would be here. We have yet to hear from the city, but I think that would be clear. What, on the other hand, we have is an act of an administrative official. I think we're probably going to hear whether there was an inspection done or whether it was customary to inspect properties in the course of issuing these amnesty licenses, if you will. And I do want to say one more thing before we get too far along, because I think it's going to be maybe very tempting to refer to our recollections from time periods, you know, long gone. We're going to need to decide this case, as every case, on the record. So we're going to have to be really cautious against introducing things which we might consider facts that aren't made part of the record.
I
May
understand.
I address Mr. Brandt's comment? This is not the city of Rehoboth versus the state of Delaware. It was the Court of Chancery interpreting city of Rehoboth ordinances. And after that court case, the city of Rehoboth amended that ordinance to make essentially what was illegal not, to make it legal as long as you registered the garage apartment within 60 days.
And then is there a follow-up from the Chancery Court, or did you go back? Did anyone go back to the Chancery Court to say free and clear?
That has not been done, but quite frankly, parties often have to exhaust their administrative remedies, and one of the ways to, before they can go to court.
Okay.
And one of the ways to do that
Fair,
was,
fair.
The city was a party to that litigation, though, correct?
that's correct.
A full party to the
A
litigation.
full party, and the city in that litigation said that they would have granted the Francis's the special exception. They said that in the court case.
Is that in the record?
That is in the court case, which is in the record, and/or I believe you can take notice of.
It's not in the written decision, though, that, in the recitation of facts, or it?
Well, no, actually, the building inspector did refer to the court case. And that's why they were finding violations and denying the rental license. That's the second document.
Well, I think that's clear, but I think it's clear that the city presently is relying on the court case for justifying its position.
And I believe that's wrong.
But is there anything in the court's order or in the decision that has been submitted that suggests that the city was inclined to grant a special exception but couldn't? And I don't think that appears in. Otherwise, why would the city why would the city bother to litigate this if they were inclined to approve it?
The city didn't litigate it. There were numerous parties, and it was neighbors that brought the lawsuit. The city was quoted in the court case by the judge as saying that they would have granted the special exception if the Francises had applied for it, but they didn't, and now you've got two neighbors suing, and this is what the court decided to do with it.
Okay.
But and the building inspector's finding of violations and denying the rental license, it references the court decision, but it does not reference the registration or the amnesty legislation, which we believe is where the building inspector got it wrong.
So you haven't spoken to building permits at all. I think the file suggests that after 1987 or something, there were no building permits issued or sought by the applicant. So these improvements that you're referring to, like when did they occur? Did they occur between the time that the decision was rendered and the amnesty ordinance was adopted, or did they occur within 60 days of the adoption, or did they occur after the license was granted?
And I don't know that, and I don't think we could know that unless we went back in time. But we do know that the Francises believe they had registered the second and third floors of the garage apartment under this amnesty legislation.
Okay, I want to follow up something Fred said. So there's no building inspector approval for the construction of a 3-story apartment. How would we, if we were to override Corey's decision, how do we know it's safe? There's no building inspector making sure. One of their primary jobs is to make sure it's safe. We could be putting someone who rents this apartment in peril. I mean, just hypothetically. I mean, there's a building inspector never got.
That's an interesting take, but that's probably not a justification for us to deny the appeal.
Fair enough.
Yeah.
Fair enough. But I'm just saying, here's a structure that didn't have a signature, even on the registration for the garage apartment. No building inspector signature. Okay, I'll hold it.
Again, what we're appealing is the basis of the building inspector's decision, relying on that court case, ignoring the registration and the amnesty legislation. As a side note, I will mention that it was inspected when the McKays sought a rental license.
Okay,
and
fair
that
enough.
was what prompted the building inspector's finding of violations and denying the rental license.
All right, thank you. Jan?
Well, did you want to go first, Rick?
Yeah, if I
Okay,
could, Jan.
that's fine.
Rick?
Fred, can we ask the city and the applicant's attorney, does anyone have these missing documents? We were talking about an action taken by the Board of Commissioners to grant amnesty, which pertains to the zoning code. In my experience, those are a matter of public hearing, and the ordinance adopted usually has a preamble that recites the reasons why the matter is being proposed for adoption. I think that's a very relevant document for us to see. And I know that counsel for the applicant doesn't feel that the letter from Glenn Mandelis that has been mentioned is not important. I found this whole case very confusing because of its history. So if nothing else, if Mr. Mandelis has provided a succinct history of this matter, I think that would be very helpful to the board in its considerations. There are just missing pieces here that, for me, make it very difficult to analyze this. And I guess another thing is the registration forms say 600 square feet. Is the applicant alleging that that was an error? I mean, I can't put all the numbers together and come up with a square footage of that building.
And if I may, Mr. Townsend mentioned looking at the legislative history of that amnesty legislation to determine intent, but you don't actually do that, particularly in court. If you can, in terms of statutory interpretation, what the statute says, what it means, you can get that from the four corners of the statute. It's only if you can't get that from the four corners of the statute, do you look to things like legislative history? I would submit that this legislation says what it says. It offered amnesty to people that had illegal, non-conforming garage apartments. It gave them an opportunity to register those so that they would become legal, non-conforming garage apartments, and you can get that from the face of the statute, from the registration. And in terms of the 600 square feet, I believe that was a non-expert estimating the floor area devoted to human habitation. It's certainly more than the second floor, which is 383 square feet, and the third floor, which is 317 square feet. Is it an error? I suppose. I think it's just a slight miscalculation. You can call that an error if you want. Again, this form was not meant to be filled out by experts. It was meant to be filled out by homeowners.
Well, I might agree that a court would not necessarily have to look outside the four corners of the ordinance, but while we are an adjudicatory body, I'm not sure, Fred, I'd have to ask you, do the rules that the court apply to us? I mean, for me, it's still an issue as to what the intent of the Board of Commissioners was.
Well, I mean, we have, and before, this reminds me, before you take your seat, I don't know if you want your clients to testify. I would like at least to put them on the record to say that the factual representations that you've made are theirs and accurate. But the applicant has, on a couple of occasions now, referred to what his client's perception of the intent of the passage of those ordinances is, and made reference to things which apparently aren't in the record. And to the extent that you are to, give credence and analyze the representations that are made, it would be helpful if we had more material. Either that or, a court, if we were adhering to court rules, we wouldn't allow much in the way of testimony of such things if there weren't supporting documents in the record.
And if I may, I mean, I was offering a lot of that information, trying to tell a story of the history of this property. I think it really boils down to a very simple issue, which is, what do you think this registration did? Did it register the second and third floors of the garage apartment or not? I think that is really perhaps the only question here, and you don't have to look at anything else. You don't have to consider anything else that I've said as far as trying to explain the history of this property. I think you can look at this registration form and decide for yourselves what was done there.
Fred, I think I see another question here, and I can't think of how to phrase it to the applicant. So may I ask you here?
Just do your best. We'll work.
Okay. I'm stymied by the applicant's attorney's definition of amnesty. We have throughout, we hear case after case where people think that because there's, and it's been with garage apartments, sheds, but garage apartments over and over again, where people feel that because they had it once and they consider the amnesty goes on forever, as I asked this gentleman earlier, and that's what he's feeling, it seems. But what we find is the strictures are, if you leave it alone 100%, it lasts as long as that building that way. But if you make changes of any sort, all of a sudden, you have to meet all of the, and you lose. It isn't a blanket. Oh, excuse me. It isn't a blanket amnesty for the rest of the property forever. But it's a conditional situation.
I agree with you, but I don't think their representations, and maybe I missed it in the facts, but this property is not being totally redeveloped or hasn't been totally redeveloped. I think the argument about, the question about the meaning of amnesty is something we're probably going to hear from the city. The applicant seems to be suggesting that amnesty means that you can do more than what you're currently doing.
Right, you changing it.
And some of us, might question whether amnesty means you can continue doing what you were doing, but you can't expand it any further. And I don't know if you wanted to speak to that.
But I look at only a few months after the July 1991 Chancery Court case, so we're talking April of '92, is this document where someone said, you have to do this to this property, and now all of a sudden you've got this. That, to me, is a disconnect, and I'm not sure quite how to approach it, Fred.
Well, you can ask for a comment from the applicant.
My understanding is that the use has not been expanded. And perhaps if it is expanded or changed, assuming the use is renting the second and third floors, that has not expanded.
But the Chancery
That has
Court
not
said
changed.
you could only rent one floor. And that was July of 1991, Chancery
And
Court.
the legislation superseded that. The legislation superseded that court decision.
If you were engaged in that activity at the time the legislation was passed, isn't that fair to say? It didn't say go out and build a garage apartment if you don't have one. It said you can continue to rent your accessory building that is outfitted for dwelling purposes or your garage apartment if it exists at the time of the ordinance and you follow these subsequent steps. At the point that legislation was passed, the prior owners had the right to make habitable only one of the 3 floors. And now we're being,
A few months later.
in just a brief period of time, we've learned that I guess perhaps they were either never in compliance after the issuance of the court decision, or they expanded further because we don't have any record of building permits that were issued in the interim.
And I would, first, I don't know that we'll ever know the answer to that question without the Francises here. But I would submit that even if they hadn't been in compliance with that court order, the legislation would have superseded the court order in any event.
When you say legislation, what are you talking about?
The ordinance.
The ordinance, when they amended the ordinance, when the city of Rehoboth amended the ordinance to allow
the legal
people.
non-conforming, if they were registered at the.
Correct.
Okay, that's.
If
so
people
when you
had a
say-
if
When you say
people-
the legislation, that's what you mean. Okay.
City of Rehoboth and this ordinance, and if you had an illegal, non-conforming garage apartment at the time, you could register it, and if you did so within the 60 days, it became legal and legal non-conforming.
Right, as long as it didn't get changed. And other things.
I believe that's correct, as
There were
long as it
other
wasn't
strictures.
expanded or changed.
There were other, yes, there were other strictures too, yes.
Can I just,
Edie, are you done?
I am, I think
Okay,
so for-
please, Jan, go ahead.
Rick had something too.
Okay.
do you want to go first?
It's a quick question.
Go ahead.
What was the nature of this building on the date that the registration form was filed? Were the second or third floor already, one of them in accordance with the court order, habitable, completed?
And I don't know if we're going to know the answer to that question without the Francises here. All we know is that in 1992, Mr. Francis filled out this registration, which in my opinion clearly includes the second and third floors with the 600 square feet and the 8 plumbing fixtures. And the question then becomes whether the registration did in fact do that.
Well,
So, may I, so the ordinance, hopefully I've got the right ordinance here, and I'm sure we're going to have it brought to our attention, is 270-46 garage apartment. Subsection A says a garage apartment which has an existing structure prior to March 12, 1976 is a non-conforming garage apartment. B, a garage apartment converted to a dwelling under a valid permit issued by the city prior to the date of this chapter shall be permitted as a non-conforming structure. That's not the case here, I don't think. C, a garage apartment or accessory building converted to a dwelling after March 12, 1976 without a valid permit issued by the city is illegal, and its use as a dwelling shall be abated, subject to D, E, F, and G. And D, within 60 days of the enactment of the chapter, the city manager shall issue a notice of the requirements contained in E, F, and G, sent by certified mail to the last known address. And then, within 220 days of the enactment, each property owner of record having been duly notified shall file on a form provided for this purpose a description, which we have here. And that was done. And then when the building inspector verifies the information contained, the building shall then be deemed to have been duly registered. That's the ordinance as you understand it. I'm sorry.
I don't have the language in front of me, but yes, I submit that this
what year?
complied with that.
Can you see what?
This
Jan see this
doesn't
document?
indicate when it was
Yeah,
adopted.
there's no dates on that.
I mean, can I ask my question now?
Yes.
All right. First of all, I was a city commissioner in 1990 and 1991 and for a number of years afterwards. And while I'm probably older than you are, I would venture to say, my memory is still relatively intact, especially as we've looked at this recently. The Bauer report, and Mr. Walton may know about this, that was passed, a total rewrite of our zoning code was passed, I believe, in either 1991, according to Mrs. Womack, and she's pretty good about that, or 1992, but I think it was 1991. Because it was the old zoning code was thrown out in my thought, and this Bauer report became the new zoning code, then the city manager at the time was asked to redo this registration of garage apartments. And so it had absolutely nothing to do with his court case.
Well, that may be,
No, I'm just telling, he's the one that said it was. I'm correcting him. It's not. It was done, this was worked over for a number of years when, Kimber Vogt and John Hughes were both mayors, and it was passed after Sam Cooper became mayor. This court case was, this Bauer report was worked on prior to this court case.
Okay. All right, any other questions for legal counsel of the applicant? All right,
I do believe the applicants would like to be heard.
yeah, okay, very good.
come forward, please, be sworn in.
Thanks for hearing this case. My name is Rick McKay. This is my partner, Jane Mangat.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do. So Jane and I were longtime friends, and after losing our spouses many years ago, found ourselves together and eager to begin a life together. The home we purchased at 17 Lake Avenue was perfect for us, and more importantly, for our grandchildren. Our hope in requesting this special exception is to be able to use the third floor in the guest house for our 12 grandkids. Presently, many of them spend their nights on the sofa or air mattresses on the main floor. To be able to use the third floor would mean we could all be together in Rehoboth. That's part of our reason for going ahead and doing this. Thank you very much.
You don't need a rental license.
And real quick, with respect to the factual representations made by your counsel, they were true and correct, or does anything need to be corrected in your mind from what was?
No, sir, and to the best of our knowledge, the unit was constructed, and I know we've made no changes to it, and not that I'm aware of, not that I've read in the documents that we've tried to find.
Thank you.
Okay?
So have you ever rented it?
No.
No, okay.
Then why do you need a rental license?
Well, part of the process, as to my understanding, was trying to apply for a rental license, and then if we were turned down, then we would apply to you to see if we could get the variance approved, so that we could have it. Instead of saying, oh, if we're going to rent to a family, and, okay, here's the main house, and by the way, you can only use the second floor, in the guest house because the first floor is a gym, so that's not set up for anybody to sleep there.
It's a gym?
Well, it's a workout area
It's
for
a
us.
workout, uh-huh.
Any further questions?
On that, no, I have no additional questions on that. Any other questions for the applicant? All right, let's turn it over to.
Thank you.
Thank you, to Corey. Thank you.
I'll start. So we're probably going to approach this just a little bit differently because we went second. We usually go first. So and we'll start off by saying that we believe this is an appeal. This is not a special exception. I don't know how one could say one got a special exception because if it was a special exception, you guys would have had to have granted.
Right.
Because that goes to the Board of Adjustment. So the city couldn't make that representation on behalf of the board in the prior hearing. Putting that aside just for the moment, the city's records, which Corey and I will go through in detail in a moment, make it crystal clear that since 1991, the city has taken the position, and it has been solid in its that this particular area cannot be occupied or cannot be habitable. And Corey has done an excellent job of putting it together, the records, which are going to walk you through. There might be a little bit of duplication in the way we prepared, but we think it'll be pretty succinct to try to get through that. So I don't know if, do you swear, Corey, in situations like this? All right, well, you're going to tell the truth, right, Corey? So let's go ahead and get started. And Corey, we're a little bit bollocksed up here because of our setup. But if we could pull up Corey's report, and then we're going to walk through the documents that he had. And this will be Corey's testimony, even though he's not sworn. Can you just go to your exhibit start? We'll
I
go
can
to
administer the oath if it would make people more comfortable.
I just wanted to be clear that this is going to be Corey's testimony. So Corey, attached to your report is BI Exhibit A. And can you just real quickly tell me what that is and what it means?
Sure. And a brief synopsis of all of these exhibits are included in the report. So I'm going to try to just read off of these synopsis. This BI Exhibit A is dated May 23rd, 1991. And in this here, I know you'll see a couple different dates in here, but the main one I pulled off for the synopsis here was the city manager, Greg Faris, issues a memorandum to the mayor and commissioners regarding the property at 17 Lake Avenue and the judge's decision. That would be Judge Hartnett of the Chancery Court. Per a portion of the memorandum, quote, please find enclosed a copy of Vice Chancellor Hartnett's decision. He does not grant Giggy's request to tear down the third floor of the building. Instead, he orders that they can only use one designated floor for residential purposes. Certain fixtures must be removed from the third floor, and that the Francises cannot rent any part of that dwelling.
Can you page down just a little bit? Keep going past the letter. Now, is that the court decision that you're referring to?
Correct.
Or is that the order?
That's the amended one, correct? Yeah.
Yes.
That
Think-
was a little bit later.
Yes.
You can see
yep,
here,
the amended
amended.
one. And then, can you go to BI Exhibit B? And just for that, that's just a little short statement there, and can you tell me about that?
Sure. BI Exhibit B is dated April 7th, 1992. Tiber Nagy, president of Tiber Nagy Home Builder Incorporated, attests that the property has complied with the court's order.
And is this in the city's file?
Correct.
And is it business record of the city?
Correct.
All right, go to BI Exhibit 3. And that's just a couple of days later, April 10th. That's a letter. Can you just quickly summarize that?
This is from attorney John J. Work from the law firm of Hudson Jones, J. Work, Williams, and Ligori, in a letter to Vice Chancellor Hartnett of the Court of Chancery, writes of his hesitation that the level of compliance to the judge's final decision would deter future habitation. He cites Tiber Nagy in this letter.
So, and can you go back to, I'm sorry, before I move on, we're going to try to do this quickly, but I think it's an important fact. Can you go back to BI Exhibit B and just emphasize the date? What date was their certification that the property had complied with the court's order? What's the date of that?
April 7th, 1992.
Okay. And so moving forward back to BI Exhibit C, is there photos attached to Mr. J-Work? I've never called him John. He was always Terry to me. Terry J-Work's letter. Is there photos attached to that if you swing down? I know they're difficult to see. Corey, do you know why those photos were attached and for what reason?
These were photos included, I believe, that showed the minimum compliance that Tiber Nagy in Exhibit B wrote about, and I believe it is shown in this exhibit here that it could be reinstated as a habitable space with relative ease, and the photos were to emphasize that point.
So, and again, and that date is April the 10th, 1992.
The clarification, he's arguing that this really isn't ripping out the plumbing fixtures. Is that what you're saying?
Yeah, on item 4 here, Mr. Nagy told me that anyone who knew what he was doing could easily replace the plumbing fixtures and restore the third floor to its prior condition with less than a day's effort. And although Mr. Nagy indicated that he did not observe any registers, if the supply ducts are in place behind the wall coverings, he said it would take no effort to cut through the wall or floor coverings and install the registers.
Thank you.
Excuse me, doesn't that reference the fact that there's solid wall or there's wall covering in front of a number of the features that were supposed to have been taken out or made non-useful?
Based on this letter, that seems to be the
That's what's stated in this letter, correct? Yeah, I'm trying to remember all the things I read as we were preparing for today.
So let's walk you through to the next exhibit, and that's dated March 30th, 1994. Excuse me, before we go on, do the pictures reference that at least most everything has been removed in
in the prior exhibit?
In the prior exhibit?
Correct.
Okay. And going on to Exhibit D, tell us about what this is.
I have to rephrase this from my report. I state that the building and licensing supervisor, John Dean II, writes a letter to the new owners of the building informing them of the court's judgment. It actually was to the seller. This was not to new owners.
It was a real.
But it was in this letter here. There are several factors regarding the rear building that I feel you and prospective buyers should be aware of. So I need to amend that section. This was to the seller of the property.
So what was the substance of the letter?
It was to inform them that the seller, in their due diligence, should make prospective buyers aware of the court's judgment of the limitations of the accessory dwelling.
And is this letter dated March 10th, or excuse me, March 30th, 1994? Is this a component of the city's records?
Yes.
And is it fair to say that it was the city's position as of March the 10th, 1994, that the area could not be habited?
Correct.
Can you page forward to BI Exhibit E? And can you tell me what that document is?
This one's dated October 23rd, 2019. Former code enforcement officer Dennis Jenny sends a notice of violation to former property owner Margaret Curl, informing her that the garage apartment, third floor, was in violation of the final order of judgment and to have the structure come into compliance as a corrective action.
Is it fair to say with respect to 17 Lake that this was October 23rd, 2019? What's the corrective action?
It's listed here, corrective action required, remove plumbing fixtures, beds, and any heating and cooling equipment from the third floor of the garage apartment.
And can you go to BI Exhibit F. Tell the board sort of what that is.
Exhibit F is dated several months later, January 29th, 2020. Again, former Code Enforcement Officer Dennis Jenny sends a final notice of violation to former property owner Margaret Curl, compelling her to bring the garage apartment into compliance.
If you read down, it says an appeal has not been filed by with the city secretary. Was an appeal to your knowledge, or did you see in the file any appeal of this decision at all?
No.
And can you flip over to the next BI, again relating to 17 Lake Garage Apartment, Exhibit G? And there's a letter and some pictures. Can you tell the board what that's about?
This was an email dated June 15th, 2020, from former Code Enforcement Officer Dennis Jenny to the building inspectors, as well as former city manager Sharon Lynn, former city attorney Glenn Mandalis, that the property owner had complied and brought the garage apartment back into compliance with his final notice of violation from January 29th, 2020.
So, and that's June 15th, 2020?
Correct.
And just let's read it for the record and tell me if I get this right. Matt and I inspected 17 Lake Avenue this morning and confirmed that the fixtures on the third floor have been removed and or made inoperable, and that the beds have also been removed. Did I read that correctly?
Yes.
And are there pictures attached here too relating to that from the city's file?
Correct.
And can you just walk through those very quickly?
This is the toilet, the sink. You can see the sink has been disconnected, and the sewer lines and water lines most likely capped. This was the bathtub and the removal of what I'm assuming of where the beds used to be.
So just let me get this straight. As of, I'm going to try to get my date straight. Give me a moment. So I believe you testified that as of January 19, 2020, there had been no appeal that had been filed with respect to the city's decision. Is that correct?
None on record.
Okay, and then according to Exhibit G, the fixtures had been removed as of June 15th, 2020.
Correct.
Let's go to BI Exhibit H. Can you tell the board what that's about?
This one here was similar to BI Exhibit D. It was from a building inspector, Matt Janis, writing a letter, not to the seller this time, but to the new owners of the building, informing them of the court's judgment. And the words used in this are very similar to the words used in BI Exhibit D. That was dated March 30th, 1994.
So, and you've written at the top, it says, because there's no date on it, or who wrote at the top, time stamped in records, April 6, 2021?
I wrote that in.
How did you determine that date?
That's the timestamp that the file was saved in property records.
Okay, thank you. So let's go to Exhibit I. And admittedly, Exhibit I has nothing to do with this particular case, but can you just sort of take a look at that and tell me what this is?
Exhibit I has for reference, additional garage apartment registration forms included from throughout the city. This first one is from a 28 Columbia. It was stamped in from the city, April 10th, 1992. It has the verification form here. This one is from 25 Park. This was stamped in February 18th, 1992. These all give similar bits of information. This one is from 7, I believe they meant to write Pennsylvania Avenue. And I think we have one more from 30 Oak Avenue.
So they would represent properties that were registered, garage apartments that were registered, is that correct?
Yes.
And each one of those is signed by the building inspector?
Yes.
Okay. Can you go to, and I know Mr. Townsend talked about 27046, and that's just, we can go to the first page of your report where it's outlined. And Mr. Townsend spent some time, but I don't know that he got all the way over to section F. And so just take a look. We didn't go over this question, but take a look at that. There was a date by with, and well, let me deal with this a little differently. Within 60 days of the enactment of the chapter, the city manager had to issue a notice that went out to property owners under the statute. Is that correct?
Correct. That's in letter D.
Right. Do you know when, or do you remember when the statute was enacted?
So that one was part of, I didn't include it as an exhibit because quite frankly, I couldn't. When I reached out to the city secretary, typically in an ordinance like this, there's an adoption date for the specific section, and there isn't one. You can go on our city code's website right now and you won't find it. So we had to do a little bit of digging, and what I found from the city secretary was what Ms. Conacy had mentioned, that this specific section was a smaller part of an entire zoning rewrite from ordinance number 991-1. So, and you can reference that in city code if you go to the top of the city's chapter 270 blanket zoning section. That's where you'll see this referenced. That was adopted September 13th, 1991.
And if you go to section E, it talks about within 200 days of enactment of the chapter. Do you see that?
Yes.
So what's the significance of that date?
So within about 7 months after the enactment of this chapter, which would have been the new zoning chapter, any property owners in Rehoboth Beach had 7 months to fill out these registration forms and send them back in to the city with the information as required.
So about what was the deadline that they had to send something into the city?
That would have been around April 11th, 1992.
And if you go back to your report, and this is where I started and I backed away from, but I don't think Mr. Townsend got to section F. In order to receive approval under this, what's required under section F of ordinance, or excuse me, code section 27046?
When the building inspector has verified the information contained in this filing, the building shall then be deemed to have been duly registered with the city of Rehoboth Beach.
So is it your testimony that the building inspector needed to sign off on that registration?
That's correct.
And so I don't know if you want to take a minute and pull up if you just give us 1 second, I'm trying to be as efficient as possible, but I'm just trying to make my record. So that's, my friend has the registration form up here on the big board. We'll do it on the thing. So is there a verification of the above information from the building inspector in this form?
No.
And in the city's records, did the city ever sign off on this attempted registration?
No.
What is the date on the attempted registration signed by Mr. Francis?
March 31st, 1992.
Now, if we go back to, sorry to make you do this, but I'm going to have you go back to Building Inspector Exhibit, Building Inspector Exhibit B. And so Exhibit B, do you recall what that was?
This is Ty Bernanke of the president of Ty Bernanke Home Builders attests that the property has complied with the court's orders.
And what's the date?
April 7th, 1992.
So isn't it true that they tried to register the property on March 31st?
As the registration form would show, yes.
And they certified that all of the stuff was gone as of the 7th of April 1992.
I would just make a note that on April 4th, 1992, I believe this was dated. He sent this April 7th, but it looks like the inspection took place April 4th.
So unless you have anything else, I'm just going to sum up. There was nothing to register as of the 31st day of March 1992 because it was already gone, and the court had already done it. The city has consistently taken the position that we walked through document by document all the years with respect to this exact property, that the space is not habitable. It's the applicant's burden to prove that the city got it wrong. The burden's on the applicant, or here the appellant. Under this set of facts, there is no, I'd say we've established that the city has taken the position that it was never registered. I would like to say about my friend, yes, we did make a reference in an earlier statement about the 600 square foot discrepancy. We're not relying upon that today. That was an error on my part because I didn't understand. And we all make mistakes, right? So that was my fault. So I apologize for that. But our position is really simple. The mere registration form, which I believe is all that we're relying upon here, listing fixtures and such, could not have vested or changed the court's decision. They had to actually have some sort of a sign-off from the building inspector. The statute requires that. But they actually had to have a unit in place at that time, and they had already been ordered to have it go away. So that's our very simple position, and we think the decision of the building inspector finding the property in non-compliance should be affirmed.
Thank you very much. I'm going back to something Edie said 30 minutes ago about, yes, you can register it, but if you make substantial changes, all bets are off, right, on this. Just taking, to a layman, a home improvement kind of guy, just taking fixtures out, if I were in charge, I would have had them pour concrete down the sewer pipes and block it off and take out the copper, take this out. And the city was kind of lax or easy on them when doing this. So I would assert that I would have had to consider the fixtures taking things out. And if you bring it back in, going back to what Edie's saying, you are making substantial changes. So then the application for grandfathering kind of is off the table. So that on top of never being inspected, never having a building inspector's report, I'm kind of having a question of like, this to me was these things were removed. Even though you let it slide, you put a plug in it, you kind of let that go. But adding that back in my mind, is substantial changes. And it's just a commentary. A question would be, up until 2021, did the city ever collect fines on this property? Did we not charge them? Not these homeowners, but the previous homeowners. Did we? I know we try to work it out with homeowners, but we didn't. Did we ever fine them with $150 a day?
It's $100.
$100 a day from 1992 up till 2019. Did
Not
we
to
ever?
my knowledge.
Okay, we never did find them. Okay. And would you, Corey, agree that adding 8 fixtures is a substantial change to a property? We have to get building permits for wallpaper. It's one of what I always like to call out, right? If you added 8 fixtures to a building, to a structure, would you consider that a substantial change?
Well, the question is more about whether it's habitable or uninhabitable.
If I could answer it in the way that I treat everything here in Rehoboth, when it comes for a zoning review, we have a non-conforming
Right.
section of our zoning code. And that speaks to if it's a non-conforming use or if it's a conforming use, but it's a non-conforming structure.
Right.
So I think it
Right.
would be wise to think about that in two different ways. Right now, if you're in an R1 district, a secondary dwelling's not only a non-conforming structure, it's also a non-conforming use because only one single-family dwelling, detached single-family dwelling is permitted in any R1 district. These registration forms allow these structures to exist on the forms here as legal non-conforming structures, but in essence, too, they're allowed to remain as a non-conforming use because they're a secondary dwelling in an R1 district. And so any changes at all to a non-conforming use require a variance. If it's a conforming use and it's just simply a non-conforming structure, it's a house but it's built a little over a setback or something, then you can do things to that. You can make modifications, but if you expand the non-conforming area, that requires a variance. Or if you remove more than 50% of it, that requires a variance. And so I'm hesitant to answer on if any changes to this would be made, as this is a non-conforming structure and a non-conforming use. All of these garage apartments are.
And we have no variances on this.
Not that we have on record.
Okay. All right, thank you.
It only seems to me like the current owners are having to deal with the, I'll be kind, the missteps of the previous owners. And it is what it is. I mean,
I have questions.
Edie?
Yeah. Corey, what is habitable space? I mean, if you think of these 3 floors the way they've been described to us, does habitable mean that you can sleep there? Or, you know, when I'm looking at these 3 drawings that this gentleman gave us, the first floor, rear door storage, HVAC storage, but is there a washer dryer on this floor?
Well, on the registration form, a washer is listed as one of the plumbing fixtures.
On the first floor?
I'm not sure what floor it's listed on,
Okay.
but it is listed on there as a
Does
washing
not say,
machine.
Edie.
So,
And
so the first floor is considered walk-through then? A walk-through place is not habitable, even if it might be a gym or a something? I'm not saying it's an
Well,
official
one of
gym.
the two main, there's a couple elements to what makes habitable space
Okay,
habitable.
that's what I want to know.
The biggest one is that, especially in areas that have winter temperatures below
Okay.
freezing, you have to be able to heat all areas of that space to at least 68 degrees.
Okay,
And that's one of the reasons why I think that the judge mentioned the HVAC units. The other one is ceiling height. We went over that in the basements more recently. These spaces have to have at least a ceiling height of 7 feet. And then you get into dwellings, and that's where provisions for living, sleeping, eating, and cooking and sanitation all have to be present. So you need to be able to have beds, you need to have a kitchen or a kitchenette, a bathroom, you need to have ventilation, ceiling heights, and the ability to heat and cool, and of course, drinkable water.
okay. When I texted you this morning, emailed you this morning about some measurements and information, just a minute, let me find, sorry. I asked you what was the square footage per floor of the most recent measurements that you had. Just a minute, I've got to find the right piece here. Sorry, there's so many papers this time. I read them all how many times? I'm sorry. I'll have to find it. Anyway, here, sorry. When I said, do you have the square footage measurements of each of the 3 floors measured by someone other than the owners? And you said no measurements provided in city records other than measurements performed by owners of the property. With that said, the city survey has on record shows 330 square feet which would be per floor, as there are 3 floors. So if you're thinking about this application or something like it, when someone's filling out floor area gross, that would be the entire building. Is that right? Is that hypothetically what they'd be filling out, or they're not filling out habitable space?
If you're referring to the garage apartment registration
Yeah.
form, the total area of the house, and I'll pull this back.
It says 1,500 here, is what the display and our copy
Correct.
says.
We would recognize that as the total square footage of all floors.
Of all
Of the
floors.
building.
And I noticed the second and third floors are slightly larger than the first floor, because it seems like, oops, there's a build-out over the entryway. So that was taken into account for square footage, or?
I imagine on this form,
It was just a-
the former property owners here did the best they could with
Right.
what they thought it would be, but I believe the intent of that 1,500 square feet was for the first, second, and third floor.
The whole thing. But as you are indicating with Max, without a sign-off from the building inspector, we can't be sure that anyone from your office looked over this and made sure that it was kosher, so to speak.
Yes, with a small caveat with that.
Okay.
Usually especially with properties like these, this was 30 years ago.
Right.
We would have building permits associated with these as well.
Okay.
And that just simply isn't the case for this,
Okay.
for this property.
And another question I asked you this morning, is there a list of the number and type of plumbing fixtures that were found in the most recent inspection by building and licensing on each floor? And you listed what you'd found. And when was that done? I didn't want to get back to you and bother you with another email this morning. I know we were all trying to get ready for today.
Those photos were in reference, I didn't include them in here, but
Yeah,
this
that's
was
okay.
from the applicant Exhibit 1, dated March 20th, 2025. Code Enforcement Officer Amanda Pombo sends a notice of
Okay.
violation.
Okay.
Those photos were included
So
with that.
here I see second floor sink, kitchen sink, bathroom sink, shower, and toilet. Third floor, bathroom sink, shower, and toilet. But I thought somebody said there was a washing machine, or, that would be a plumbing fixture, isn't it?
Correct. And I won't dispute that there may be some
Others,
other fixtures that just simply weren't included in photos
okay.
that may have existed.
So did your office do that list, or did you take it from something the applicant or the owners had submitted previously?
I took it from what I could tell this morning from the code enforcement's photos attached with that notice of violation.
So this may not be exactly what is in that building.
Correct.
Or it may be. We
That was
don't know, is the point. This at least is the minimum of the plumbing fixtures that exist, but there may be others, and we don't know that because nobody from your office has been inside to actually look at it
Well,
recently.
I believe the code enforcement officers were there, but I couldn't reach them this morning.
Oh.
They did take photos, and that's what I saw
Okay.
of the photos.
Okay. And then the other thing that I asked was a copy of the 2025 rental license application that was filed by the owners. I thought I had seen reference to that in our materials, that had been refused or something. And so, and that generated some of this situation. But you said the last rental license issued to this property was for the house, and it expired in 2021. That's what you
That's what our
mentioned.
software
That's what
system
your
has on
software says. So again, I have a disconnect here. And I don't know what to do about it, Barry and the rest of you guys. So I know those aren't really questions per se, they're questions for Corey, but I keep coming up with it, with kind of going back to what Rick said, is it seems like there are things I should be able to read or know that I don't read or know. But that's all I have right now,
Okay.
Barry. Maybe I'll come up with more.
Thank you. Thank you, Edie. Rick, any questions for the building inspector? Or Max?
So to your knowledge, Other than the sign-off on the bottom of the registration form by the building inspector, there would have been no other formal communication from the city acknowledging that the registration was accepted or denied? Is that what I'm to presume from the fact that there's nothing presented here other than the registration forms?
Without the signature of the building inspector, all I have to go, all the city has on the record there was from the letter from Tiber Nagy, who stated that the plumbing fixtures were removed and there were no registers there, which means that I take it that the wall coverings would have covered that. So what we would have looked for without any signature would have been a subsequent building permit to bring the floors back into habitable, spaces that they did in fact have a smoke detector. They did have the supply and return ducts that they would need for heating and cooling, and that the plumbing was reconnected.
I think my reading of the court decision clearly, as amended, was intended only to require that the fixtures be removed. What the reason for that was, I don't know. Maybe the expense of having to rip out all of the plumbing and stuff rather than just removing fixtures. But from that standpoint, seems to be, and based on Mr. Nagy's affirmation to the court, they were in compliance, at least with respect to paragraph 5 of the court order. Am I correct that since that time, none of those fixtures have been reintroduced?
Not in the form of a building permit or a plumbing permit.
But have they been reintroduced without a building permit or?
I imagine so because of the 2019 former code enforcement officer Dennis Jenny, his notice of violation. I don't have it in records on how he came to know that was occurring.
Okay, but the pictures that you took this morning, or whatever date it was, showed only the rough plumbing there. Were those the most recent pictures? Am I mistaken?
Are you talking about the color pictures?
The colors are from Amanda, I believe, and then the black and
Correct.
white ones were from the original one.
I want to see if I can.
That was in connection with something Max said that you and he had visited the property? No? I misheard that? Okay. I've been there.
So, yeah, we don't have, it's not introduced here in the record. There are photos, they're not included here though. But they did show, that's what I relied on to count the number of fixtures. And those photos would have come from
The color pictures,
March
my notes say that they
2025.
were in G, your G. The color ones, and maybe I have the wrong one, but
So those pictures, just for to clarify the record, the pictures that were in Exhibit G were from June 15, 2020.
2020, oh, okay.
Yep.
Okay.
Yep.
That
Right.
came as a result of former code enforcement officer Dennis Jenny,
Okay,
the notice of violation.
then not
Okay.
from Amanda, I stand corrected, okay.
Okay. I do have a couple more. You finished?
I'm finished.
Okay, go ahead,
Am I
Edie.
making you crazy?
No.
Okay, let's see. So do we know what the layout of the 3 floors was? And I think we don't, but can ask. Before 1991, after 1991, and now? I mean, do we have anything that tells us, other than these little pictures or these little drawings that this gentleman gave us an hour or so ago as we began? Do we know the layout of those floors and what's actually in them?
Those are from the file.
But how old? I mean, they're not dated or,
Yeah, but they are from the file. They're not, they weren't produced by the
right,
applicant.
right. I wasn't saying they were really.
So
I'm just saying this is the first we ever saw them today. Everything else that he gave us today, we had in our other information, our other couple hundred pages. But these were new to us today.
We don't have any floor plans from 1991 or
Okay.
before 1991.
Okay.
We don't have any floor plans from between 1991 and when the date that those were created. There's nothing of record. And then we don't have any current floor plans.
And we don't know what date these were made.
Those do exist. I would ask, I don't know the date of those.
Okay.
Of those.
Yeah.
Those are like assessment, maybe, could the assessment office produce something like that? Or could,
Possibly.
or using the building permit records that they have on hand?
Possibly,
For
but
this purpose.
I believe that the first is what the applicant said. It's kind of like a carport storage area. You can't, there's no way to live in that space. The second floor is what we would call, it's a dwelling unit. It has a kitchenette in it and it has the means to live. And the third floor is, it's essentially just another floor without beds or plumbing fixtures right now. I don't know if it has the registers off the top of my head for air conditioning and heating.
I know we're really at the point of everybody who isn't here, please stand up, because we're with what could be or what isn't there. But if there had been, if changes had been made with building permits, you would have drawings and, I mean, all along, right? If the work had been done with building permits.
If they changed and altered reconfigured the space, most likely, or we would look for some type of permit that had,
And which doesn't exist.
not that we could find.
Right.
No.
Right. Let me see if I had anything else here. I don't. There's still things I don't know, but I've tried. It seems like when we ask some of these things, we can't get answers, and it isn't because everybody isn't trying to answer.
Okay.
Thank you.
No other questions. At this point, I want to open it up to the public for their commentary. So is there anyone here who wishes to speak? Please, sir, come forward. Mr. Townsend will swear you in.
Stand up here or sit down?
Name and
whatever
address,
you want.
please.
Pardon?
Name and address when you're ready.
Bruce Vivari, 12605 St. James Road, Rockville, Maryland, 20850.
Mr. Vivari, that's
Okay.
a familiar name.
Yes, so we're the property owners next door at 19 Lake Avenue.
Can you will you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I can. Okay. Boy, you've heard a lot already, but I guess I would start off by saying I'm just so disgusted to even be here today. This whole issue has been a thorn, I'm being polite, in the side of us, the city. It's been dragging on for years, and I don't know why this particular house attracts this kind of abusive behavior, but it somehow it does. We won't go through Judge Hartnett's decision, recap all of that, except to say that originally the house was supposed to have an attic, and then the attic got taller, and then it became a full-size room. And the city didn't really enforce the building code. There are lots of people did a lot of wrong things, but nothing egregious. And that's how we ended up in the situation where Judge Hartnett said, okay, I'm going to leave it, but with these conditions. And that's what I really want to try to emphasize here. You've heard all of the testimony about only the second floor is habitable. With all these numbers here, 300 square feet and 1,500 square feet and 300 per floor, none of these numbers add up. It just doesn't add up. Right. And I contend that this application is further proof that it was never accepted in the amnesty program. It was not signed. It was not dated by a building inspector. So absence of approval to me is denial. And I caution you to rely too much on emphasis with that particular application. And, you know, as Mr. Kondrashau asserts, that, you know, different people have tried to do these various situations, and that this amnesty program completely usurps the court's judgment. That to me is just egregious hubris, and I find that unacceptable, and I hope you do too. What else is going on here? So what you don't know also is in May of 2021, on the main building, my neighbors decided to remodel a bathroom. Again, did not seek a building permit, had a stop work order, and then they had to pay a fine and then continue on. If you look at the letter up here, it says that the third floor is fully equipped with bathroom fixtures. Everything's been reinstalled again. No permit was applied for. Okay, there's this pattern of abusive behavior that just goes on over and over again. And I wish the dang third floor was just torn down. That's not in your purview, but that would have saved us so much of this grief and aggravation. And as the lawyer said before, this is going to go on. We'll be back here, you know, hopefully, not anytime soon, but we'll be back here. And I don't know what you can do to permanently, you know, stop this sort of stuff from happening, but that's what I'm asking. I'm just asking you to deny the owner's appeal. Proceeding any further is just going to continue, you know, further litigation, and it's just really frustrating. And in closing, we have laws, we have ordinances, we had the judge, we had a trial, he had an order, and I think we need to respect the law. So, thank you.
Thank you very much. Anyone else wish to speak? Okay, at this point, I'll close down the
If I may, with your indulgence.
I looked this way and look over. Please.
I had wanted to give a
Yes.
rebuttal and
Yeah,
summary.
we did, yeah, we did say that.
Now, there's been a lot of information today, a lot of questions, and I think it's actually very simple. The applicants are here today appealing the building inspector's decision, and the building inspector based their decision on the 1991 court case. And I have all the respect in the world for Mr. Walton. Mr. Walton's elaboration, clarification, stated, you are correct that the code was amended in 1992 to provide limited amnesty for garage apartments under limited circumstances. For your client's property, only one 600 square foot unit was registered. That's what we're here, that's what we're told the basis of the building inspector's decision was. The 1991 court case, and this 600 square feet is only one floor. That's what we were told, that's what we're appealing, that's why we're here. There's been a lot of other information, but I think those are the only two questions that really need to be answered. And it's not hubris, it's the law, that legislation supersedes court cases. And so the question becomes, with respect to the court case, did this legislation supersede the court case? I submit to you that it did. And did the Francises register the second and third floors of the garage apartment under the amnesty legislation? There's also been a lot of information about who was in compliance when, or someone wasn't in compliance. I would note that I think it was Mr. Abernathy's letter said they were in compliance. He was on the other side of this case. He was the neighbor's attorney that sued. He didn't like this case. He didn't like the Francises. He didn't like the court's order. The court's order was actually amended to say that fixtures had to be removed, but they didn't have to rip out pipes and such. So, and I'm sorry, it may have been Mr. J. Work. He wrote that letter saying it was bare minimum compliance because he just didn't like it. But it was compliance. But again, I submit to you that none of that really matters. Who was in compliance when? There was the court case, regardless of whether there was compliance, there was the amnesty legislation that superseded the court case. As far as the registration, this is the first time the city has made an issue to me of it not being signed. And I dealt with the former city solicitor, Glenn Mandalis. I've dealt with the current city solicitor, Max Walton. The city has never refuted this before today. It was clearly received by the city. It has the city's stamp on it. It's in the city's files. Why isn't it signed? I don't know, but I think they would have to explain that. Again, I don't want the board to get lost in the weeds. I think there's two questions, and compliance is not necessarily one of them. Was the 1991 court case superseded by the legislation? Did this 600 square feet register the second and third floors of the apartment? And that's it. Thank you.
Thank you very much. Okay, now we will be closing down the public portion. Thank you very much. And I'm going to open this up. I am not a lawyer. I can't make a decision. I listen, about whether legislation overrides a court case, what's valid or what's not. But what's sticking in my head is the simple fact that 270-46 has been made very clear. F requires the building inspector to approve. And based on the evidence I see here, I do not see approval. I see a registration that it looks like it was brought into the city, but never approved. So I'm going to argue with my board members here that how could we overturn, a building inspector's decision because, we haven't done 270-46F. That's kind of the point I'm at right now in my mind. Change my mind, flip my mind here or whatever. So open it up to you guys. Your thoughts.
You're an attorney, why don't you?
Well, I mean, we'll ask you that question, Rick. Can legislation, overturn a court? I mean, I'm not allowed to ask that, but, of another board member.
Yeah.
Yeah, I mean, Congress can adopt legislation that negates a decision by the Supreme Court.
Good point. Now, what about 270-46F, which is, where I'm kind of hung up on that, stating, when the building inspector has verified the information, keyword, the information contained in this filing, particular filing for this garage apartment, then the building shall then be deemed to have been duly registered, which I means properly registered, with the city of Rehoboth Beach. And that's kind of where I'm stuck. If I went down the path of trying to agree with overturning the building inspector's decision.
Well, if I may, I think
Please.
that paragraph G is also important because it further explains what are the consequences of not being registered in accordance with the provisions in this part of the code. And if it's not registered, then it's considered to be illegally erected or altered.
Illegal.
Right. I mean, as I see it, someone mentioned that there are, I wouldn't say a comedy of errors because it's by no means a comedy, but there are people who are no longer alive who did things that affected this property. There is a court order. Without more information from the city records, I find it difficult to figure out whether or not this legislation, or if you want to call it that, but this change to the zoning code was truly intended to address this particular court case. And it seems to me as though from the time of the court case through the relatively current period of time, the city has consistently not viewed this code change as overturning that court decision. And I really feel for the current owners because they're, you know, I don't know how much you knew about this property and how much was disclosed to you when you bought it. But you're now stuck with an unenviable situation that I'm not sure how to rectify at this point.
I mean, just speculation. I mean, there is a structure. It has 3 floors. It has plumbing fixtures in it. I mean, I would hope that somehow they could use a portion thereof, but I don't know how to get through that, and that's not for us to decide here.
Yeah, I mean,
This is just whether we agree with the building inspector or we do not agree, or we modify the building inspector's decision.
I agree with Rick and Edie, and I can't see in my wildest dreams how that could possibly have a rental license for that 3-story unit. You know, it's been a nightmare, and I, you know, have a lot of sympathy for you. But clearly, the city has never acquiesced to the fact that it's legal and that everybody's been doing things above board. And I'm very uncomfortable with that.
Edie, any additional thoughts here?
Well, I was nodding in my head as you were speaking, Barry, at the very beginning of our time right here of this discussion. I made notes here that it seems there's been a blatant disregard of the city successfully by several owners from 1986 on, that anything that was under the radar was okay or could be worked out. And I wonder what even granting the decision, what then complying would be. Complying seems like a cat and mouse game here between a couple of entities. Now you see it, now you don't. I think there's more awareness of what the situation is than perhaps has been admitted. Right. And there's been, it seems, skirting an issue, ignoring an issue. I do feel for the current owners, but I was just looking while Jan was speaking, and I didn't get it yet, because didn't Matt write his building, the number H of yours, Corey? Could you bring that up? Isn't that when Matt wrote a letter to these owners, because these owners bought in 2021, right? I'm pretty sure they did. It's your number H.
It's the code enforcement, Amanda's Bombo's letter.
Yeah.
Yeah.
Yeah, and so, I mean, that was saying, hey, there could be trouble in River City. Robert Preston, Music Man. I'm not making light of this. I know it's a very serious incident for everyone. But this was 2021, and these are the people who were buying in 2021. They're named in this letter. So now it's 2025. If there have been issues, or why are we now looking at an appeal where there were more than rumors that there was something that wasn't right, at least one thing.
Is this the letter that was to the sellers or the?
It's to the, I believe it's.
Oh, no, it
look,
says,
they're
okay,
named.
you got
It's
it. I got
there,
it. Got
yeah.
it. I'm sorry.
It's from Matt Janis.
Yeah,
I'm
it's
sorry.
named.
I've got
It's
it.
named.
Okay.
I remembered reading this.
I stand
In
corrected.
the 15 times I read this stuff. But, so I'm saying there was hey, red flags, at least one, 4 years ago. And, now here we are, 4 years later, with something, I just, I'm with you, Barry. That's where I am. I can't
we want a
see
motion?
reversing the building inspectors. I can't see granting the appeal.
Yeah.
I can't see that.
Rick?
Yeah, I would just like to ask the building inspector, would the city recognize the right to use the second floor as habitable space, given that the court order said that's the only floor they could use, subject to a permit?
Yes.
Okay.
So there is a workable solution.
But they just can't, they can't have a rental license, though. They can use it for their grandchildren.
Right.
But how are you, how
use
are
it-
you going to choose to comply?
They can use it for their renters, but only the one floor. And the renters of the main dwelling would be able to occupy it.
Is that correct?
That's correct.
And that's not for us to decide, that's for building inspector with the owners and the city.
Let me, let me rephrase. We would go through all of the review process for that. But that.
There could possibly be solutions here. So I'm going to ask, can I get a motion here? It's going to be a tough one.
I move that we deny the appeal.
Okay, based on,
Second it.
based on,
Based on the fact that I think that the building inspector has made every effort to let the owners know that there were issues. We don't use Quick Check for this, right?
No.
Not for an appeal.
Your focus is on whether or not
building-
the building official has applied the code correctly in
I
this
see.
instance, which is to permit or deny an application for a rental license.
Okay. Then I move to deny the appeal based on the fact that the building inspector has interpreted the code correctly to deny the rental license.
and may I get a second?
I second.
Okay, and I'll start with you, Jan, on your decision and, again, restating your reasons why.
I think the building inspector and the city attorney have clearly demonstrated, factually, all the reasons why it should not get a rental license
Okay,
and why their decision was correct.
all right, thank you. Edie?
I think the building inspector has correctly interpreted the appropriate code sections of 270, and the license should be denied. That should have been denied and was denied correctly.
Okay, Rick? Thank you.
I agree that this should be denied. I clearly feel for the property owners and the dilemma they have found themselves in, but I do believe that the building inspector has more than adequately investigated this matter and has discovered as much as is available within the city records without undue burden to substantiate the decision that was made by the building inspector. I am particularly, the three things in particular that lead me to my decision are the unsigned registration form and the paragraphs in 270-46 F and G. Thank you.
Thank you, Rick. And I too agree with the motion. And, while I am not an expert to say whether legislation overrides, the Chancery Court, I do agree that 270-46 F and G were the right decisions made by the building inspector. So that's my decision. So the appeal does not carry. Building inspector's report stands. Thank you. And at this point, thank you for your time. And we're going to take a 5-minute recess. We need it. Thank you. Okay, mics are back on. Okay, our third case of the day is 330 Rehoboth Avenue. I'm going to ask Diana to give us a real quick intro here for a second.
Good afternoon. My name is Diana Stewart. I'm from Smittinger and Rodriguez, and I'm stepping in for Mr. Townsend because he has a conflict. The applicant, Mr. Carlton Savage, was previously represented by another colleague of Mr. Townsend and his firm, Rick Burrell. So I'm here covering to absolve that conflict.
Thank you, Diana, and welcome. Okay, at this point, we're going to get started, and I'm going to ask the building inspector to present his report.
Thank you, Mr. Chairman. This is case number 0525-06 for 330 Rehoboth. The applicant is the property owner, 330 Hospitality Group LLC. They are represented today by Carlton Savage Jr., Senior Engineer of Scaled Engineering Incorporated. This variance, under this variance request, the applicant seeks relief from the following: 270-11 use restrictions for the R1 district, as well as 270-21A natural area and 270-21C lot coverage. The nature of this request is to allow for the continued existence of a non-conforming on-grade parking lot through an anticipated minor subdivision of land of a C1 R1 split zoning parcel, along with any modifications to the property as it relates to commercial uses. This request is only sought for that residual residential portion of a split-zoned parcel as depicted in the subdivision plan submitted by the applicant, which I will put on the screen now. I'll zoom out after I'm done with this. The application also notes any new property created with R1 zoning only would be required to conform to all applicable codes of that district. The applicant requests any variance granted to run with the property or the deed, so long as the use is associated with the commercial structure on the parcel of land the residual residential portion is included in. This current property is located at 330 Rehoboth Avenue and is situated in both the C1 Central Commercial District and the R1 Residential District. The property is irregular in size, and the submitted survey conducted by Foresight Services dated December 13th, 2013 shows the property contains approximately 42,494 square feet. I will reserve going into the application background information if there are questions, but that is provided in the building inspector's report. Again, going over the variances requested, the applicant is seeking relief from 270-11, which this portion of our code states that the R1 district is designed to protect and maintain those residential areas now developed primarily with single-family detached dwellings and primarily on lots of at least 5,000 square feet. The applicant first seeks relief from the above use regulations, specifically to allow the use of an existing on-grade parking lot in an R1 district. While 2 off-street parking spaces are required for each dwelling in an R1 district, the only permitted primary use of this district is a single-family detached dwelling. The applicant also seeks relief from the natural area requirement to allow less than 50% of the gross lot area and less than 50% of the front yard setback to be natural area for the existing on-grade parking lot to remain. And the applicant further seeks relief from the maximum 40% lot coverage as required in R1 districts to allow for the continued use of an on-grade parking lot. In conclusion, as stated in the applicant's variance request, should the variance be granted and the property be redeveloped commercially, all other sections of code not receiving the variance will apply to the property. Also, should the variance be granted and the property chosen to be subdivided, any new property created with R1 zoning only would be required to conform to all applicable codes of that district. And further, should the variance be granted, the variance should run with the property or the deed unless no remaining portion of the R1 property exists. This variance request seeks relief not only from natural area and lot coverage, but of use as well. It is recommended that should this variance be granted, clarity should be sought as to other uses than an on-grade parking lot be considered in a potential site plan review in a future application. Questions like, Are the following also considered acceptable uses? Loading/unloading berths, sidewalks, storage of refuse, and other various accessory uses. That concludes the report.
Thank you. Question for you. Is there an existing variance on this property now, the R1, that allows the parking lot to sit on top of it?
Not that I could find, no.
So,
That of a Board of Adjustment?
okay, so there's no variance. So we've had a R1 property for 40-plus years, 100% covered. And the reason, and my understanding is R1 is to allow rainwater runoff. And so I guess my point is, I'm kind of shocked that there's no variance in place, and this parking lot has been sitting there for 40 years and never been remediated to allow rainwater runoff. So am I incorrect in that position?
You may be correct, but from
Stormwater
my...
advocate, how nice.
I'm kind of like, I mean, I vaguely remember the Seahorse restaurant being there, my younger, coming down here, but I'm just kind of like, wait a minute, this is R1, and it's 100%. So this is the first request for a variance. I guess what I'm want to get is what triggered this? What triggered the need for a variance to leave something as is, I guess?
That would be parcel alteration.
Partial, okay.
So this is in anticipation of a minor subdivision. And when they do that, when they alter a parcel, they can't create new nonconformities or
Right.
not or exacerbate existing ones.
Okay.
And the reconfiguring of this parcel would do such.
Is that trigger? Okay. Real quick question, by the way. Sussex County has the lots correct. Rehoboth Beach, and if you go to the zoning map, is wrong. So just FYI, if anyone's listening from the tech team wants to fix that. And I guess this is an open question. The lots are legally connected, correct?
Yes.
That is correct. This is all deeded as one
Okay.
parcel.
And I had trouble trying to find, I forget the exact term, split zone. I couldn't find anything in Rehoboth Beach Code on the definition. And I guess what I'm getting at is I cannot understand why the Planning Commission would have created this entity. And maybe that's something that goes back years. But we have no code for this thing called split zone, and it leaves us in a quandary on how to deal with this.
I've unfortunately sat through many hearings on 330 Rehoboth.
Okay.
It's my understanding there's a historical explanation of why that happened. I don't exactly remember what it was,
Good.
but the definition of split zone is you have one big parcel that has two different zonings.
Okay.
That's it.
Yeah, but then how do we treat it? Treat it commercially? Treat it residentially?
I think
That's
the
why we're
applicant's
here.
going to explain today. That's why they're here.
That's why we're here. Okay. And okay, you heard my rant about asphalt. I'm good with my questions. Jan?
All right, I will ask verbal aloud the question that I've wondered since we got this, and that is, this is a great, better plan than I've seen before, with the residents and everything. It's very nice, except why don't you get it partitioned and have the two residential lots be partitioned, and then you have the other lot left that I presume you're going to use. No,
But that's not to building inspector.
I mean, was that not suggested to the building inspector by the building department, that it really is a partitioning? And if they partition the two lots off that they want for residential, then they have the lot left that they want to use for parking, is my assumption. That's what they want to use for. I have no idea. But why wouldn't you partition this? I mean, we just went through at our last presentation, it's having to stop in the middle of a hearing on Scarborough Avenue Extension, and I don't want to have to do that again. I would prefer to understand why this isn't being partitioned first, and then if they need a variance, because nobody wants to change the zoning from commercial to residential. I mean, it's been turned down by the city commission and the court, everybody. So I think this is a great plan, but I don't think that it should be coming to us first. I think it should be partitioning first, and then Because how can we have two sets of rules for two,
What are the two sets of rules?
Well, this is going to be houses,
Right.
according to this picture here. This is going to be a parking lot. And so then you have two entirely different uses, maybe is the right word, for this property. And then there's lots of other issues, like buffers and.
Let me ask Jan's question in another way, if I may interrupt here. What we see in purple, the variance is requesting for the entire purple, correct?
No,
Okay, so
only
Mike,
for this.
what I'm going to try to get at for Jan is if a variance is approved, we, as the board, are approving 100% coverage on a residential property where you could build a little house with a big asphalt pad around it, which does not meet code and why a variance is being asked. And that kind of hurts, I know it hurts my head as to why don't you just fix it and make it right?
But we're really being asked to look at two things, right? We have a use variance. And then we have a two area variances. But to my mind, and this is a question for Corey, if we don't grant the use variance, the area variances become moot for this case, right?
Correct.
Correct. So we have to focus on the use, in my view, focus on the use variance first.
Agree.
Which is the use for two single-family houses.
No.
No, it isn't.
It's to
all we're
use, it's to
being
use it
asked-
for the parking.
Yeah, we're
Use
just
for
being asked
parking.
to approve everything that's in purple to be parking, right?
Parking, right.
Is that what the request is? Even
Then
though
why
you
are there
tell
two
us,
houses here?
even though you're showing us that in
driveways?
fact,
To
there are
just-
going to be two houses.
One at a time, please.
If I-
Yeah. Go ahead, Max.
I would like the building inspector to have a chance. There was a lot said there, just to
Yeah,
dive
okay.
in. Could go ahead on the partition.
Sure. So I want, it sounds like some of these questions, well, the applicant can absolutely
right.
answer. But from my understanding, speaking with the applicant, reading over their variance request, currently, and for many, many years now, the property in purple and some in the triangle up here in yellow has existed as parking, essentially on-grade
No,
parking.
I'm very aware.
They're here because the minor subdivision in redrawing, in subdividing land, they can't do that and then create nonconformities or have a nonconformity there. So oftentimes, one of the conditions, if they do that, is for the applicant to, within a certain time period, come in for a demolition permit or a building permit of some kind to get the property into zoning compliance so that no nonconformities exist through this parcel alteration, the redrawing of lines, of lot lines. And so the applicant is here today to seek a variance to keep the existing on-grade parking lot that's shown there through a minor subdivision, so that they could keep the parking lot and not have to completely demolish. Because without that, then our zoning codes would state the entire portion of the residential portion of this parcel would have to comply with R1.
But I
zoning
thought
codes.
that the use as a parking lot is grandfathered in, so that it is still, it can be a parking lot.
There's no variance for it.
There's no variant, it's grandfathered, though. It's grandfathered because of use. Absolutely. The parking lot is not grandfathered?
Everyone
That's-
has, that's been argued, but
Right.
unfortunately,
So it's an oddball situation. It's a non-conforming parking lot, period, as it sits today. When you do a subdivision, a partition, whatever, it loses its character, it becomes as such. So yes, it can stay there today, but for them to be able to do something with it, they need the variance.
So I hate to put it in this order, is they went in and asked for a demo of the R1 asphalt, rip it up, make it dirt, then asked for a variance, wouldn't that be an order that, to see if we would agree with that? And then they would have to asphalt it over again. I mean, I'm being a little facetious here. It's kind of, it's like, I think I understand why the planning commission says, nah, you got to get it conforming. Yeah, that makes sense to me. And, you know, but if we turn around and approve a variance on this, we're basically granting asphalt 100% coverages for what, and even the applicant has stated, and we'll ask him again, that he wasn't sure how he's going to handle this property, which means we would be approving a 100% covered lot that could potentially be developed residentially as it is, and no subdivision.
It was, so I'm going to let the applicant speak about that, but it's my understanding, and certainly with the conditions that I discussed with Corey, which are in the letter, right, it's just to be used for parking. In other words, you know, we're not going to have other accessory structures. The end of your note talks about using it for garbage collection, and, you know, those are things that need to be looked at.
Loading berths.
Loading berths, et cetera.
Whatever.
So this, as I see it, it's, and you guys, I think, could tailor it to be narrow to that purpose.
Right.
Okay, I'm still unclear. Are we being asked to give a variance for a whole purple area or for the purple area that is marked as being the future parking?
I'm gonna let the applicant
Okay.
tell you exactly
Fair
what
enough.
they're looking
I
for.
have a couple more questions for Corey before we move on to the applicant. Did any of the rest of you? No, okay. So as I was reading it, the wish for a subdivision is the baseline, could be the baseline situation. And can you define minor and major subdivision? I don't know what that is.
Correct, yeah. A lot separation is simply 1 to 2. That's a separation.
And that's
A
called minor?
That's in, you're going to find these in the definitions portions of chapter 236,
Okay.
subdivision of land.
Okay, I missed that.
That's a separation. A minor is anything that is 3 or less
3 or less what?
lots. I believe in the major subdivision, excuse me, that's, my apologies, it's between 3 and 5, I believe. And anything that, the way the major subdivision is worded is anything that's not a minor subdivision. So they don't have a limit on it. For instance, Walls Apartments just had a minor subdivision. They divided a parcel into 4. That was treated as a minor. And there could be some that have the same but are treated as a major. I think it's really the extension of new roads, new services,
Okay.
or on existing.
But the first thing you said wasn't minor or major.
This was for an anticipated
separation?
minor subdivision.
No, but you said something about a separation. That's not before, when I first asked the question, you told me about lot separation, and then you told me about minor and major.
I see. That might have been through a hypothetical for, just as an example of a parcel alteration.
Okay, so that's not either one.
What's shown up on here is, and we can let the applicant say
Sure,
this,
sure,
but this comes
sure.
from the applicant, is to anticipate a residential lot 1, residential lot 2, and then this purple as well as the yellow here as a 3rd lot.
Okay,
Right now, it exists as 1 parcel.
okay, so they're looking for 3, so it's minor.
That it would be treated as a minor
Minor,
subdivision.
okay.
But we're not subdividing it, that's the whole thing. We're not partitioning it. That's not what they're asking for. They're not asking us to partition it. They're asking us to change the usage, the variance on the one that doesn't have houses on it.
So that it could be in the future, I mean, perhaps.
But we don't know. I
Right,
mean,
well, we'll ask.
Let the applicant
Okay. and
explain
what-
that to us.
What could exist without our changing anything? I mean, that you've talked to the applicant probably more than once. What could exist that meets code, or is what they want just has to be a variance, or it has to be a big change here?
Well, if they didn't do anything.
Right.
This has remained for many years.
Right.
So we wouldn't force them to tear out the
Right.
parking lot. The residential portion of it would have to comply with all R1 zoning codes.
So they couldn't just choose the R1 portion and subdivide that into appropriate size lots, whatever code, and use that. There has to be a physical minor subdivision first, and the planning commission gets involved in that, right? I mean, I'm trying to understand, I saw so many, well, I'm trying to understand where they're going, I guess.
I'll try
I'm
to
still-
clarify in the simplest way that I understand
That'd be
it.
great.
They came in originally wanting to have a minor subdivision.
Okay.
They didn't, I don't even think that this was brought out to their attention at first.
I see.
And then they were informed that the parcel alteration couldn't be done and keep the parking lot the way that they wanted to
Okay.
without seeking a variance first.
Okay.
Otherwise, they could very well just would get to the planning commission for minor subdivision and be told immediately, we're not going to create a non-conforming here or
see.
have a non-conforming by parcel alteration.
Okay.
Edie, can you hold on, Mr. Walton?
I think we had a misstatement of what a minor subdivision was, unless I looked it up. Includes any subdivision containing 3 or more lots fronting on an existing state, county, or municipal street, not involving any new street or road, or the extension of the city or county affiliate facilities, and then it goes on. So it's 3 or more. So partition is 2, 3 or more. A major subdivision has an odd definition. It's anything that's not a partition or a minor.
Okay.
But the gold is not up. It's only the purple that we're talking about, which is already zone residential, and you could build as many houses as you want on it. You know, I mean, you could build lots of residential things on this if you met the residential code, like dividing them up, partitioning it into 3 lots if that's what you wanted to do. So you don't need a variance to keep it residential.
Maybe the idea isn't to be residential. Maybe I
Absolutely.
saw
No,
words.
Well, we know, but
I
if
saw
we-
words
We
for
we should
hotel.
we should let the
Yes.
applicant
Well,
it
say
is a
what
hotel.
it is they
Yeah,
want. 'cause I think
absolutely.
it's a different issue.
So any other questions for the building inspector? Rick?
No.
Edie?
No, not now.
Okay.
I-
Okay, let's turn it over to the applicant.
Thanks for your patience.
Thank you.
Can you state your name and address for the record?
Good afternoon. My name is Carlton Savage Jr. I'm a senior engineer at Scaled Engineering here in Rehoboth Beach, Delaware, 20246 Coastal Highway, Rehoboth Beach, Delaware.
Mr. Savage, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Absolutely.
Thank you.
So yeah,
Please
hopefully I
proceed.
can answer most of the questions that you just had. So where this all started, so this application is for a property known as 330 Rehoboth Avenue that Corey described, specifically parcel 334-14.17-139.00. That parcel is one singular parcel that has 2 zoning designations, hence the split zoning definition we just talked about. This basically started when there was an application for rezoning of the property, which was denied, which would have corrected all of these issues that we are talking about today, and would make it much easier for redevelopment to occur. That was denied. I don't intend to go into that for this meeting. I think there's been a lot of discussion about that. The request for today is to simply allow a singular use to remain on the property. So the entire portion of that purple right now is parking and has been parking for years. The intent of the variance would allow that parking to remain as we go through other applications. So when I came in and talked to Corey for the first time, actually, I'll take a step back. My clients, which is known as 330 Hospitality Group, they are behind me today. They can answer any questions or attest to what I'm saying is their desire. They came to me and they asked, as an engineer, what could be done with the property? And immediately I said, it's very tough. Anything that we want to try to do here is going to require a variance because of the split zoning. The city's zoning code, when it talks about FAR, singular buildings on the property, so I can't do anything without subdividing the property more than one singular building. That has been changed in the code a few years back. So we would be stuck with on that R1 portion of the property, which is somewhere in the nature of, just so we're clear, I have the residential portion of the property being approximately 19,425.6 square feet. So it would be an extremely large residential property on its own. So I think we would be left with, as a singular R1 property, be allowed to build one house and one house alone with, meeting all the FAR and parking requirements and all the R1 district requirements. That clearly wasn't the intention of what the clients would like to do. So we started talking about what could be built on the commercial portion and what could the residential portion be used for. And immediately, you can't use anything commercial on the R1 portion, so we would not be able to build anything that was related or an accessory use to the commercial property. And I think the intent was some sort of mixed use is where their head is now. However, that, as we know, that process is very intensive to get to a site plan approval, to start doing drawings. So we met with Corey, and we said, we brought this plan to Corey's attention. Actually, I think we had a meeting pre-Corey, somewhere in the middle of a transition where Corey was taking over the commercial. So I think we actually met with Matt Janis first, and then met with Corey afterwards to clear up the discussion. And during that discussion, we realized that we could not even submit for a partitioning, which I think this is what this would be. 2 lots would be a partitioning in this case. We don't get to the 3 lots, which is a minor sub. Corey would not even be able to review that plan, or Planning Commission review that plan, without trying to figure out how to leave the remainder of the property conforming. And that gets into a whole different discussion when it comes to if we do subdivide, which is the intent of the client right now is 2 lots, subdivide those off, make those no longer, sell those off or build houses, whatever it may be on those 2 properties. That would have to go before planning and zoning, and the first thing they're going to tell us is come in here and get a variance, because they won't be able to partition those off without a variance on the property because it makes the existing building non-conforming. So it's a first step.
I don't understand that. What is it that would be non-conforming other than the parking lot?
So if we remove any parking space out here and demolish those parking spaces, my understanding, and you'll see in my application and language, that the city's position is removing a portion of this parking lot for a minor subdivision or a partitioning would render the remainder of the property continue, I guess, the nonconformance, but it would make it more nonconforming than it is today. Because Corey would have to do a review of certain things like the building, is there enough parking remaining for the existing building, the use of the building, all of those things would have to be reviewed by Corey as part of the subdivision process.
And who told you that?
Corey.
I mean, I talked to some people on the Planning Commission, and they're saying it should have come to them first for partitioning.
So
And
This was discussed beyond just building and licensing. And if they were to come in for a minor subdivision, they couldn't create a new residential lot. If you look here at Lot 1,
Which one is Lot 1, the bottom one?
the bottom one here.
Okay.
Just as an example, they couldn't create this now and have it completely just blanketed by asphalt parking. They would have to, as a condition, come in with a demolition or a removal permit.
So if the asphalt
to
was
remove
removed, still trying to figure out why we're here. If you remove the asphalt from the purple and then say, hey, Planning Commission, we'd like to make these 3 residential, I think the Planning Commission would be, okay.
it's two residential.
Or
3.
or the
There's,
third.
there's, this would be just residual that would be in portion.
Where are you pointing?
Right,
I don't see the cursor.
I don't know.
Oh, there it is. Okay, that would be residential as well.
this
So
would
3
be one, well, as shown in here at least, a residual portion of this R1C1, which would be 1 parcel.
And then you'd have-
These 2 lots, they couldn't create these 2 lots here as shown, and what I understood the applicant as they wanted it, without, so from what I understand, and the applicant can say that they do intend if lots 1 and lots 2 are subdivided, to be completely demolished and to have single-family dwellings built on them.
All asphalt removed.
All asphalt
so
removed,
that-
but to
that's just
keep the
building.
residual portion here. Now, if no variance were sought, then what we would say is that as a condition of, of a parcel alteration, anything in this purple area would have to be ripped up and brought back to natural area to meet the R1 standards. You couldn't create lots 1 and 2 here and have it be completely covered.
I understand it. So in a sense, that odd-shaped, large purple remaining lot has to come into compliance before the Building and Planning Commission would say, we will listen for a subdivision.
Or as a condition of maybe to have it be completely removed.
And if that that odd, I want to call it the odd-shaped purple lot, is it, I want to ask you, is it meant to be turned into residential?
No. So the plan right now would be, I think working through the steps here, the first step would be get a blanket easement or a blanket approval for the use that's already been there. And then as we go through the process, it's very easy. I mean, hypothetically, if we come in for a site plan on that odd-shaped purple piece, and we're required to move that around a little bit, and we draw lines out here before we do this, we could render what we need done.
Okay, but from the cost perspective, if you cleared all 3 lots, then ask the Planning Commission, you know, can you please subdivide this? It'll still be residential, and then you would come back to us and say, may I get a variance, a use variance? Because my concern and fear is we would be granting for the entire purple to stay asphalt in perpetuity.
That's right.
When
No. So the request here is for the purple area, all the purple area. There's actually little hash lines up here. So we couldn't right now go and demolish the parking lot because we would render the existing building non-conforming at that point. The building's conforming because of the parking lot. The second we go in there and put a shovel and remove parking, we actually are removing parking spaces from that building. So we're stuck. Like every time me and Corey were going down paths of what we could do here, we get to the same dilemma, which is we need a variance before he can review anything pretty much.
Yeah, but I think what you're hearing is, I don't think that there's an inclination to give you a blanket variance to keep the existing parking lot in perpetuity. So if that's what you're asking, I don't think that there's anything I'm hearing about why should we do that?
Because it renders the entire property undeveloped.
No, but hear me out. I think if you were saying what you're looking for is a variance as to the odd-shaped area only, and that the other 2 can be broken off and be made into residential, I think there's something to talk about, because then we end up with a lot less asphalt. But I don't see why we would sit here and say you can keep the asphalt on State Road in perpetuity in a residential area. It's been a non-conforming use for a long time. That's not our issue.
Yeah, sure.
But if what you were saying is that you want to be able to keep, I'll call it Lot 3, the odd one. That if you want a variance for Lot 3 only, so that if you break off 1 and 2, you don't lose that ability, that's at least something to talk about, because there's a lot less asphalt.
That is the intent. That is the absolute.
Intent doesn't work here. It's got to be binding. It's got to be, this is all you get.
Okay.
One of the things we've learned in this committee is intent, since it runs with the land, and there are lots of things that have gone on here. People sit in your seat, tell us what they're going to do, they get a variance, and then we find out months later that isn't what they did. So I think it seems to me that the only way that I think you're going to get any movement here is, it's not intent, it is the variance is granted to allow you to break off 1 and 2 to be residential, to allow what I'll call 3 to remain as, for non-conforming use.
If that is the exact thing we would like to do, and maybe the application of getting the variance and then restricting ourselves for Lot 1 and 2 as they get pulled away would be reduced from the variance. I think we're all on the same page.
Bill, but I have an issue with
I
that.
have lots of issues.
Yeah, because the Planning Commission is going to say that purple lot, if you want to subdivide that residential lot into 3 residential lots, make it conforming, which means asphalt has to come up, has to be removed from lots 1, 2, and 3. Then I believe the Planning Commission say, now we'll talk to you. But I understand your perspective. That puts an impact onto the C1 lot.
Correct.
But now, I'm going to try to argue here. Lot 1 and 2 and 3 have been sitting for 40 years with asphalt on it. No one's fined the owners. You know, in other words, can that C1, and again, I can't speculate here, Corey, can that C1 sit in a condition where it's got to be developed and be corrected to allow them to move forward, getting those 3 lots? Again, I shouldn't be trying to solve this. In other words, get the 3 purple lots into conformity, then the planning commission will hear you, and then work on the Gold's commercial lot.
But it's a huge lot. It's larger than the Coast Hotel. I mean, it is larger than, I don't know what it's called.
So it should be
Dominic's
fine.
Hotel.
It
It's
should
a
be fine.
huge
Yeah,
lot.
but I thought that what I call 3, they're not planning to make residential.
No, they're not.
That's what I thought.
No, lot.
You are
about
correct.
a
Bill,
hotel. Am I right?
you are correct.
They're not planning to make that
I think what they're
residential.
planning is that 1 and 2 will be houses, 3 will get basically
picture
merged with the
anyway.
commercial.
And then they would have to
And-
com-
And
I'm sorry.
they want to continue to use that as parking for the commercial.
And they
Is
would
that a-
have to,
Correct. So
Yes.
the original proposal was for a hotel. I think we all knew that was what was there. We clearly can't do a hotel here with the residual parking being a parking lot. I'm fine with putting a caveat on the approval if it's acceptable, that if we don't do the minor subdivision, the variance would go away. But I think we have to put the variance there so we can move forward with the paperwork that needs to be done.
Yep.
And if we don't do the minor or the partitioning, the variance would no longer be valid for the whole
Well, let
property.
me ask you something. If we gave you a variance for these 2, right? So, I mean, the variance and your 10 and 10 is to split off these 2 for houses. Would you be okay if we required that a variance, that those 2 lots be turned into single-family houses?
Oh, yeah, that's the intent. The intent is to drive.
No, what the intent is, people come here, as
I
Bill
can't-
said.
I can't-
You cannot believe, I won't say, they prevaricate. Maybe, is that a better
but
word?
Jan, I think, I hate to jump in here, we're talking over each other, but I don't think the planning commission's going to hear from them, because they have to turn the whole thing into conforming, which means take up the asphalt, and sadly, they may then have to come back for us after it's subdivided. Lots 1 and 2 go off in
No, I'm
residential.
talking about if we subdivide, if we agree to variances, then there needs to be other criteria. There's no buffers, as somebody wrote us a letter.
We don't have any subdivision.
No, I'm
authority.
talking about subdivision for partitioning. I mean, I'm sorry, subdivision for variances. I'm talking about criteria for variances. As Bill said, we're not just going to give you a variance, we're going to you're going to have criteria for it.
No, I think what Barry is saying is that he doesn't think the planning commission,
Is going to hear from
if we granted a variance for what I call R3, that R3 can remain a parking lot, even if they break off 1 and 2. You're saying the planning commission. will
They're going to say no.
That's very nice, but so
Yeah,
what?
thank you. Back
Okay.
to square one.
No, I don't think they will. Honestly.
so-
But I don't know. Why don't you go, I mean, I guess I don't know.
So the one thing that makes this a little bit, trying to get through the whole process.
Thank you. I'm
I
sorry,
understand you
continue.
guys are confused, and honestly, that's why we're here, is because this property is extremely different than, there are, I think, a few other split zone properties that you'll hear about later down the road, I'm sure, but looking at this property, it's definitely unique. There's no doubt this is not a unique situation. Unfortunately, the easy correction here was to basically rezone the property to allow everything that would be
Understood.
allowed. Now we're asking for, I think, the least amount of relief possible, basically asking for what's already there to stay there permissibly while we go through the process of the subdivision, while we go through that. I'm fine putting those restrictions on the approval if it were to be granted, that if we can't use, we would subdivide the 2 properties off. That variance would allow us to do that. Now, this is a use variance, which is a little different than I think most of the variances you guys are hearing. A little bit different set of rules for a use variance versus a zoning variance. And in this case, the one thing is unique. That is one of the conditions that you have to satisfy. Is the property unique? And absolutely, in this case, it's a unique property because it's, again, not even a defined part of your code to be split zoned. There are multiple code sections here that would render Without a variance or relief here, it would render this property undevelopable without basically going, like nuking the whole thing, going back to grass and then starting over, which is a very tough thing for a developer or any landowner to do. You know, if you wanted to add a shed to your property, but you had to tear your house down first to make it happen, for the possibility of getting a shed, I don't think many people would do that. So we need some assurance from this board to take to the Planning and Zoning Board, and then so Corey can do his review without just saying, this isn't conforming, this isn't conforming. This would allow us to move forward with the Planning Commission. They might deny the request for subdivision if that happens, or they may put different stipulations on the request. They may say that we don't like the lots 50 feet wide. We want to go all over. We want to move that line a little bit.
But that's their purview. They can
They can
do that. But again, where I'm hung up is we do quick check factors
Yep.
on these. And I agree with number 2. It's unique.
But
But
not
number
for
one-
use.
Not for you.
Not for
No,
use.
I'm looking at use. Quick check factors
Yeah,
for
oh,
use.
okay.
There is some overlap. but
Yeah,
we can-
you're right,
Yeah,
no, but I'm
yeah.
looking at these.
I
didn't
cannot
think
get-
they were called quick check.
I call them quick checks.
That's
Right.
I mean, just if I went flat out and said the property cannot yield a reasonable return when used for only the permitted use. Well, geez, residential.
You can't,
Yeah.
but you can't use it residentially right now. We can't physically build a house on that property because we can't apply for a permit for a house on that property.
Why?
Because you're only allowed one main dwelling or one main building on it. So we can't even apply for a building permit for a single house on the R1 portion. We can't even rent parking spaces on the parking lot there because that's a commercial use in R1. It can continue to be used right now with the commercial building, but like we couldn't make money off that parking lot without someone in that building.
So let me hear me out. I know it's this crazy split zone. Corey, can you put a house on a commercial lot?
Yes.
Yes.
Okay. So crazy as it sounds, I mean, and I know where the planning, you want to get it split into 3, just trying to get it to the easiest path possible. If I were to say the use of that purple area, can it yield a reasonable return when it's used as residential? I would say, yes, it could. You could get 3 homes in there, beautiful homes, big lots, especially, and then can you use the commercial? I think, yeah, probably not as a hotel. So I can't get past quick check factor number 1. And then the 4th one is all uses permitted on the land under existing zoning are economically unfeasible. It's feasible once you got it partitioned to put homes there. So I'm stuck on 1 and 4 of the use quick check factors. But I understand the steps you have to go through to get it to that condition.
My question back to you would be, for me to put a house on lots 1 and 2, I've been, going through the process.
Right.
I can't request that.
You can't.
We
at this
went
point,
in. We
at
went in
this
to
point,
request that,
right.
and immediately the request came back and said you need a variance to touch anything, modify anything on this property. That's where we're kind of stuck, and that does fall into in my opinion, the quick checks, because you can't develop this property without this variance.
So if you develop these 2 houses, say we give you the variance and you
Lots 1 and 2,
on lots
Jan's
1 and
pointing
2.
to.
Oh, I'm sorry, lots 1 and 2. Would you then count them as, when you go to the Planning Commission, as part of your overall? No, so they would immediately be, and we could put that in, that those 2 lots would not be able to be counted in your request for a subdivision.
The only thing that would be added would be it's hard to see here, but there is a black dashed area in that odd-shaped 3rd lot. It's actually not a 3rd lot, so we would not intend to subdivide that 3rd lot off because we wouldn't have the road frontage without making another split zone property.
Right.
So it's sort of, to go 50-50 and then another 50, you'd end up with a really large.
I'm just talking about the 2,
Yep.
the 2 lots that you all put on your thing.
Correct.
And that's what I've been looking at. And so, and then also, we had a letter from somebody in Scarborough Village. I mean, Barry talked about drainage. Drainage is a real issue over there.
Sure.
And what about, fencing and landscaping and separation of these properties from the Scarborough Village properties? I mean, at this point, as Bill said, if we're going to do a variance, we're going to put a lot of criteria in it.
And you can condition that approval on the planning commission's approval as well. The variance request can be conditioned. You can make that part of your vote, is that approval to obtain approval from the planning commission.
I mean, to be honest with you, we're not even at the stage where we're looking at the drainage yet. I think is for us to go in and do building plans and have Corey review such building plans, we would have to know, is it permissible to use that as parking? If not, it renders pretty much, well, it does render the entire R1 portion undevelopable until the commercial building is completely removed.
So how would you are you doing underground parking? Is that what your plan is?
No, our plan would be, honestly, the plan right now is 2 residential lots. They get developed.
that, yeah.
All the pavement comes off the residential lots.
Right.
They get developed 2 single-family homes. They obviously would have to conform with all the rules,
Right.
regulations.
I
If they have a
understand that,
pool, they got to go through that. And then the remainder of the R1 portion is basically what you're granting the variance for. That would be allowed to be at-ground parking for the whatever building we decide to build on the commercial piece. And the reason it's much smaller than us saying we want the whole piece of land is because if we do hypothetically like 8 multifamily units on the 2nd floor or 3rd floor, that gives us a small little parking lot for those residential uses. And also getting off of State Road is much easier than an entrance off of Rehoboth. So that is a big part of the design process. Is we would basically keep the entrance where it is, or shift it a little bit further from the intersection potentially, depending on how that building looks. And then this remainder of the property that's in that odd-shaped purple area would end up being the above-ground parking lot for the mixed-use building. Now, we haven't designed said building, so we don't know if we need 10, 8. We would be restricted to whatever we could park there. But trying to develop the commercial piece without a small parking lot, you're going to remove all the residential uses in entirety. You're going to force whatever entrance or loading off of the Rehoboth Avenue. So it really is a design component, and I think when we looked at the plan, it's like this makes perfect sense if a variance is possible.
When you went to the planning commission previously, I assume you went asking for the whole thing commercial, and they said no, right?
We did not go to the planning commission. So this is.
Oh, the commissioners?
We didn't go to any, for this plan, we have not gone to any planning and zoning board. This is a use variance to allow the continued use.
No, I understand that. I thought this is 330 Rehoboth Avenue. It's been in the news before. I thought you went
For rezoning.
for rezoning.
Oh,
They
yeah,
went
yeah.
through
For the
the
That's what
rezoning.
I'm asking.
Yeah.
You asked for all that purple to be commercial, and they said no, correct?
Correct.
Did you ever have the conversation with them about this idea? Saying, hey, look, could we get this piece commercial, the odd lot 3, and turn the others in residential? Did that conversation ever come up?
It did not come up. This is a side effect of the denial.
Understood.
So the
Okay.
denial
Okay.
happened, and then that's really where we started. Is we went through the process of asking ourselves, how could we develop this property?
Okay.
And given its unique
Fair.
character, we kept hitting roadblocks where unless we were to put a line right on that purple and create some really odd shape in the middle here, you end up with hitting a roadblock that we can't do that without tearing the building down.
Understood.
So this allows us to move forward. Now, the other thing that this does do, it sounds weird to be saying that parking becomes a buffer, but that parking lot that's going to be there ends up being a buffer between the R1 and the commercial. There's only, I think, 3 properties in your entire town that has C1 up next to R1. So it's not a touching use that you typically see. So that parking lot is going to be, a very good, area to buffer between somebody's single-family house and, say, a mixed-use commercial.
The end of Sussex Street all backs up to C1.
Yeah.
Royal Farms, and,
We have to balance all of this Barry started on what the criteria are to obtain a use variance. So we have property can't yield a reasonable return when used only for the permitted use. The need for the variance is due to unique circumstances and not general conditions in the neighborhood. The use sought will not alter the essential character of the locality, and all uses permitted on the land under existing zoning are economically unfeasible. And we've been discussing around this. But this parenthetical remark, this test is difficult because a use variance permits property to be used in a manner otherwise prohibited by the zoning code. Use variances are generally not favored because a rezoning instead of a use variance is the proper method to seek a change in use. Use variances cannot be granted unless the proposed use is consistent with the municipality's comprehensive plan. And I looked up the comprehensive plan last night, and I'm not going. Don't worry, I'm not going to read all this. But I marked a couple of things. No, don't worry. I'm a detail fanatic. But in 824. I'm just going to read just a couple things. There are a number of concerns about the adverse impact on adjoining properties and the immediate neighborhoods in terms of water runoff, we're talking about this, noise, vegetation, architectural compatibility, and the loss of open space. This is from the comprehensive plan, by the way. The approval process is no longer adequate for review of partitioning applications because it gives the city very few tools to minimize the possible adverse effects. So the city's working on this. By the way, this is from the most recent CDP of 2010. And one other thing, in 832, called commercial controls, there should be an examination of the uses allowed in all commercial zoning categories along with their height, frontage, setback, and coverage limitations. Because of the close proximity of many residential and commercial zones, which is exactly what we're talking about here, the potential for adverse impacts of commercial activities upon residential neighborhoods is quite strong. For example, the C3 commercial district abuts residential in every instance. While these designations are appropriate, several of these uses allowed within the district are questionable, i.e. hotels, motels, laboratories, and they give some other examples. The management of the mix of business in the downtown C1 commercial district is a key concern of the city. And anyway, so they're talking about the future of mixed use, which is what we're talking about here. Mixed use is probably on every street that bisects or that crosses Rehoboth Avenue, that we have it over and over again. And the last thing is in 8.322, in its review of the zoning code, the city will eliminate, this is its goal, will eliminate any currently permitted commercial uses or categories of use that have clear potential for adverse impact on residential neighborhoods. I'm not against any of this. I'm just bringing this up as a consideration. But when we look at this map, I see, green residential. I see the two that we've talked about as 1 and 2 purple would be residential, and there we're talking. We blithely say, well, yeah, it'll be right next to it, and maybe it won't be a deal, and maybe it won't. But we know what's all the consternation we had not long ago about a parking lot on a street, and what that might do to and that level parking lot. A couple months ago we had, not that, and every case is different. I know that. I'm not trying to prejudge, but I thought it would be worth looking at the CDP, since that's a specific mention of what to consider when looking at uses.
Yeah, I hear all that. The fact is, it's already a parking lot.
Right.
So, I think that's one.
Right.
Two.
Agreed.
As the applicant said, with the C1 there on Rehoboth Avenue, what would we, ideally, what would we want on the turn on the state? As he said, in theory, I guess you could make all the purple into 2 residential, much larger lots, but then you end up with one of them bordering whatever he's going to put into C1. I don't see why we think that's a great thing. B, I agree that I'd rather have the parking for whatever they build on Rehoboth coming off State Road, than off of Rehoboth Avenue, because the last thing we want is cars pulling in and out of Rehoboth Avenue, since it's impossible to do.
Right.
In reality. So I understand all the points you raised, Edie, but we're dealing with an existing asphalt, as Barry said, that's been there for a long time, and if this greatly reduces the amount of asphalt, if we put all the conditions on, and given the fact that we know it borders on a C1 that is going to be developed, preserving this is obviously up to the Planning Commission ultimately, but preserving this as a way to get into that building and parking in that building rather than coming off of Rehoboth Avenue. I don't think they'll let them have a cut on Rehoboth Avenue, to tell you the truth.
Unfortunately, they do.
Well,
They're putting 3 up by.
we don't need more cuts into Rehoboth Avenue. It's impossible to safely ride a bike or anything else on it at this point anyway.
Right, Barry, could I?
Rick, yeah, we haven't heard from Rick.
I just want
Thanks, Bill.
to, taking, in response to Edie's recitation of parts of the CDP, I think we should not lose sight also that the CDP encourages revitalization and redevelopment of the west end of Rehoboth Avenue.
Yes, it does.
And so that's part of the consideration that is fairly important. Personally, I look at that land on Rehoboth Avenue as a detraction from the city's, character and uniqueness. I was never around in time for the Seahorse, but it seems to me as though doing anything we can to comply with the CDP in terms of making that area, more consistent with the overall and overarching intent of the CDP, which is to maintain the character and uniqueness in all of the city. Some flexibility should come into play here.
In a nice way, you're saying that if the C1 was developed as mixed use and the purple lots were split correctly residentially, that if a variance was needed in the future, it may be viewed favorably as as an exceptional practical difficulty for parking. I don't know.
Probably view it favorably. I can't imagine why it was ever zoned R1 to begin with, but that's
Who we
past
can't.
history.
That's over the dam.
It wasn't even in my lifetime.
It probably was even before we had a zoning code.
I was probably in the 40s.
Yeah.
Let me ask the board, is it someone willing to make
Well, can I ask?
a motion?
ask
Certainly,
a
Jan,
question?
certainly.
Is this?
Oh, that's right,
Scarborough
I'm
Village
sorry,
here?
yeah, public.
Is this Scarborough Village?
Yes, the green.
Okay.
Yep.
And so if you had 2 houses here I would not want to buy a house on State Road right there, but that's my own feeling. But
You just made an argument in favor.
Would you like to buy a parking
Hey,
lot?
that's Country Club Estates, what,
you know what? Not right there, it's not, let me tell you something. You're not leaving there. But no, I was just in the Belmore, the Belmore
Yes.
actually has a single-family home on their property that they rent as a single. Were you all thinking of doing something like that? No, she's shaking her head no.
They're trying to generate the revenue to make this developable, and that is part of the uniqueness here is tearing something down. I don't know the financial side of all of it, but that is a huge consideration in these decisions is how do we get this project moving to revitalize it, to get it to work.
Well, as a person who's extremely interested in stormwater, amazingly enough, I appreciate that, Barry, but it's asphalt, it's gonna get, I mean, it's gonna get, this'll probably stay asphalt, but there are other things like, buffers between you and Scarborough Village, serious buffers that mean something, the landscaping, the trees and all that. You all have the ability to make this look a lot nicer Then it really.
And I'm anticipating that the Planning and Zoning Board will think much like you are right now and put some, they're going to take comments from the public and they're going to, my guess is this parking lot will probably have to come up and be put back down. But that's not, that's a use, that's why we're asking for the use. In my mind, I would like to go through sort of the criteria myself, so you can kind of hear as I go through the quick checks myself, where my head is and give some statements there, as well as one question I would like to pose to Corey potentially that might help your decision, that's been coming up in my mind throughout this. If this variance was not granted in some way, shape, or form, could we actually develop this property? Without tearing the building down, is this property developable as it sits here today without some variance? And we feel like this variance is the least. We're just asking for what's there temporarily.
Understood.
So are you looking still at a hotel or at apartments or?
The next step would be drawing up most likely a mixed-use building for that corner.
So a mixed use and mixed use.
Commercial first floor, possibly commercial second, apartments on the third is what the client's goals are currently.
Okay. Just curious.
Yep. No, I mean that, and there's a lot of work that goes into that. There's a lot of setbacks. There's a lot of all these other things that Corey's got a lot of work to do to make sure that he gets that right and we get that right. But I am hopeful that the use variance allows us to make these next steps.
Thank you.
Barry, could I ask a question?
Rick. Sure.
Could I ask a question of council? We seem to be looking at this property as if it were two different parcels, but it's not. So when we talk about, for example, under the use variance standards, the property cannot yield a reasonable return, are we talking about the parcel, which is under common ownership, cannot? Or are we talking about certain zoned portions of the parcel?
I believe it needs to be looked at as the parcel, the entire parcel.
That's what I would think, okay. To me, that makes a big difference.
Can I,
Good-
when you mean
that's a good
entire
perspective,
parcel, do you
Rick.
mean all the purple or the purple and yellow
The
together?
purple and yellow
Both.
together
Okay,
are
all right.
one
Very good,
single
Very good
parcel.
perspective.
Okay,
And
One parcel now is through definition.
Yeah.
okay.
I can
Okay,
pull
and
up a
as
current
I-
survey
But pardon?
as it looks today.
Yeah.
That doesn't have these lines, if you'd like.
Understood.
Okay, no, I got
Understood.
it. It's
Yeah.
fine.
The colors
It's
of
fine.
that.
Yeah.
Yeah,
Try to use your colors, by the way, that match your map. So if you were familiar with them, they
Yeah.
would.
Thank you.
Yeah, it's
There we go. All right.
That's
and-
all one parcel.
And as I look up, the
Not this
public
one.
has disappeared and the lights are out behind us.
I think you wanted to go.
Oh, you wanted to go something?
Yep,
Yep,
else?
I would like to
Oh,
go
okay,
through, I'd like to
certainly.
go through my four criteria
Okay,
here.
please.
Just so you can hear where we are. So criteria one, can the property, and the word is property, yield a reasonable return? And my response to that would be, the property is currently essentially unoccupied as a use, and the building itself has gotten to a point where it needs improvement. It is understood that the existing lot cannot be used or rented as a standalone commercial parking lot. Any change of use or modification to the building or parking lot would require a variance. The R1 portion of the property could not be used as R1 without subdivision, and subdivision would also require modification to the existing parking lot and a site plan, so therefore also requiring the variance. So financially, the property cannot be redeveloped, which is what it's in need of. And even going in here and changing the use of the building, in my opinion, I think in Corey's opinion, as we've talked, would render a variance being required then. So if we wanted to put an auto dealership here, can't do it. So it's pretty much non-conforming. So we got to correct that for one. Criteria two, the unique circumstance of the property. Is this similar to other properties? I did go through, there are a few other split zone properties. I didn't find any actual R1, C1 split zone. There was, the Belmore is a property that appears to be split zoned, has 3 different zoning districts, and it has multiple uses. How that property got to be the way it is, I assume the zoning code revolved around it, is my guess. So it is unknown if any other properties have been previously approved or denied for a use variance similar to this request. It is also unknown if any other split zoned within the municipal boundaries, specifically C1 to R1. So this property is unique, is that I believe it is the only C1 R1 split zone property in the city. The other, also, there are very few C1 to R1 properties that aren't split zone that are touching each other. You have M&T Bank that touches an R1 property, C1 touching R1. You have the Baymart Shopping Center, the back of it touches R1. And I think the third one I believe it's the Belmore property, has some R1 on itself, touching itself. So it is unique in that fashion. It is not similar to a majority of the other lots in town. Can this be claimed by others? I don't think there's any other properties that currently have a parking lot that's in a R1 district that is associated with a building. So I would have to argue that it is not a difficulty of other users in town or other property owners. This lot, we might be running out of electricity on this. And then obviously the zoning allows for parking. So zoning does allow for parking as a use. What it doesn't allow is parking lot. So there is parking on every residential property. We require a couple spaces. So the use itself as parking is allowable. The use as a parking lot is not allowable. So that's why we're here. It's actually the request needs to be for the variance for a parking lot to exist.
Understood.
Is it going to essentially alter the character of the locality? And I think we all know it's been here for 40 years. If keeping it may keep the condition the same as it's been for years, I think we all want to improve that, which is why we're here. So the condition will remain unchanged other than the items required as we progress through the site plan or the subdivision plan approval. These would be requests from the city to approve conditions if required. So in essence, our goal is to keep whatever parking is in that odd-shaped piece when it's all said and done. That shape, that parking lot would essentially be the same or improved from what's there today. But no other use could be in that area. No dumpsters, no loading docks. We're not asking for that today. I would like to not have to come back for any of that, but if we get into the site plan process and for some reason a loading dock is an item, we'd have to address that. But I think at that point, we're at a point where, Mr. Perry has mentioned that if we can see the overall plan at that point, the variance could be specific to one item and probably be favorable if everything else looks good. Criteria 4, which is essentially the big one for use variances, is this a needs based request? So is this a need versus a want? And I think given all the top three, the first three, to redevelop this property, a variance is absolutely needed. This isn't something we're here asking. We're asking for a variance because anything we do on this property needs or requires this variance to move forward. It is almost impossible, if not impossible, to redevelop this property in its current condition without a variance. So we are, since the building has run its course and would need modification, renovation, reconstruction, the parking lot would become non-conforming, and to use a parking lot in any other way would need this variance. The parking lot could not legally be used as a commercial parking lot for profit or a renovated building. So those are the reasons that I see that this is a proper and acceptable use variance as I've gone through the quick check similar to what you guys have to do.
Thank you. Any other questions? Okay, I do want to acknowledge that we did receive correspondence, a letter from Lynn and Suraba Sirastada on Country Club Drive, and a letter from Michael Strange from 4 Stokely Street. So we did receive that, and everyone from the board has read them.
Yep.
And at this point, I was making a kind of joke that the public keeps diminishing as we sit here. Thank you for staying. Would anyone like to speak? Absolutely.
Thank you. Can you state your name and address for the record, please?
Yeah, Leanne Wilkinson. I live in Lewis. Where do I live? 2020 Savannah Circle in Lewis.
Okay.
Yeah. This is my mom. That's my dad. They're partners with this guy.
Can I have you raise your right hand?
Oh, sure,
Okay,
sure.
and do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
Thank you.
So
Sorry to
anyway,
interrupt.
I'm here just because you guys have got this dropped onto you, like, and you're like, why are we even looking at this? And I think a little bit of history is maybe good. So when they were under contract to buy this property and they came to talk to people at the city, none of which are here now. Corey was not here then, am I right? It was suggested, or they suggested, maybe we go to the Board of Adjustments, I think that's what you guys are called, to get a variance. And they were told, no, 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 don't do that. You need to apply for a zoning change. So for almost 5 years, they've been dealing with this. And it has gotten bounced around and back and forth. I don't think you've ever been to the Planning Commission. I'm really hoping that you all can see the big picture of this and help with this. I know you're like, hey, people ask for this and then they do something else. I get that. You have to figure out how to write this and make them agree to it, which they will. So it turns out just like they're saying they want it to turn out if they get the site plan approved by the Planning Commission and then whoever else has to see it here in Rehoboth. So what I think they want to do is the best thing that they could do because they didn't get the zoning change. The 2 residential lots, I wouldn't want to live on State Road either, but some people will. There'll be 2 lots backing up to 2 other lots. There are condos or townhouses or whatever they are. Scarborough Village has been there forever. I worked at the Seahorse 50 years ago. I am 65 years old. I worked there as 15-year-old, but I was going there with my parents way before that. So that parking lot's been there for probably 65 years, not 40 years. So I think if you can just help out by trying to like figure out how to write this and say yes to this so they can go on to the next step, because this has been very, 92 and 88, this has been very challenging for them, and I'm hoping that you all can just look at it logically and hopefully help out here so they can go to the next thing.
Right. Thank you.
And I do have to leave.
Thank you. Thank you very much. Okay, no other questions? Okay, at this point, I'm going to close down the public portion, and we will discuss amongst ourselves this request for a use variance. Anyone want to kick it off, start?
Mr. Savage, when he gave his summary, was very good, but he was using the area quick check criteria, not these, right?
No, I think
I think you used the
No,
use
he was
ones.
used,
Okay,
yeah.
because,
There's some similar language in both of them,
Okay.
especially
Yeah.
on,
Okay.
at least the first 3
okay,
criteria.
okay, all right. I'm not against any of it, but because the 4th one is all uses of the land permitted under existing zoning regulations are economically unfeasible.
He skipped that and read
Yeah,
the needs base,
yeah,
but
okay,
yeah, I think
okay.
he stated it accurately.
Okay, all right, well, that's fine, I just wanted to be sure we were on, I know we need to justify our decisions carefully, and so I wanted to be sure that we were all literally on the same page.
You may just kick this kind of thoughts off. I just think, the way forward sounds great,
Yeah,
right? But I think the steps we're going through here just seem wrong or correct to me. As you said, the asphalt may have to come up, and the asphalt may have to go back down in some future case. I just have a hard time approving a variance that could leave the condition of the land in a position that's just not what's intended or what you intended. Again, we protect the land, so to speak. That's our role here, and to try to get I just think the variance is in the wrong spot at the wrong time. It might be a variance in the future between that C zoning, the demolition. You can't touch it. If you touch one corner of that asphalt, as we're led to believe, then the whole C1 building has to come down. Okay, that sounds like a variance somewhere in the future. I don't know, but I just have a hard time in my mind with the process we are taking here to get to what I believe is a good intended result. I just don't think it's the right steps in the right order.
It's almost as if we're being asked to approve a ghost, which isn't part of the, you know.
We're not there yet.
So we're an empty train car, if you will, or something, that gets somebody to the next step, but there isn't anything concrete for us to say, we did a good thing that we can point to, we feel right about that thing, because what it is a step to the next thing. So I don't know how to phrase something like that.
And we can only see things in the variances that are put in front of us.
Right.
We can't see,
Do you
we
have
can't see
something,
the future.
Bill, or
Well, I've got to be guided, a fair amount by what the city tells us are the available steps. I think it's a given that nobody wants to keep that empty building there. As Rick and others said, it's a total eyesore.
Right.
So we almost need a joint meeting of the Board of Adjustment and the Planning Commission.
Absolutely.
Seriously, which is not the first time I felt that way, but it's not, it's because the question is, who should be taking the first step? I agree with Barry that you almost feel like it does need to be the Planning Commission, but they throw so many things to us saying they won't take a step until we do something. I don't want to say no to these folks and leave them with no options.
Right, right.
And I hear you, Barry, that you're not quite sure that this is the right option, but how do we find the right one that doesn't end up, they're 5 years into this thing, the hotel's obviously gone, but that they're not spending another 2 years dealing between us, the building inspector, and the Planning Commission.
I want to let Max speak.
Yeah, I just wanted to highlight what Diana said earlier. So it's a little bit of a chicken and egg. Like the Planning Commission might say, oh, it shouldn't be us first. And I'm not here to influence your decision on this variance one way or the other. But certainly if you're inclined to move forward, you could say that this variance is contingent upon approval of the Planning Commission of 2 lots, et cetera. Put that on, you could put that in your contingency factor. And then if the Planning Commission, it doesn't come true or it's materially different than what was proposed, or something happened down the road, to Jen's comment, then you would have a hook to say, okay, that's a conditional variance. I'm not a big fan of conditional variances, but in this particular case, it's an option just because of the oddity. Look, I've been doing land use 25 years, and this is sort of the oddest sort of thing that I have seen. So being just fair, but I just don't want to foreclose that as a potential option here.
Barry, if I could. Max, thank you, because as I was sitting here thinking about what can we do, that's exactly where I was going. And while conditional variances are not, particularly, in vogue, I think this whole situation with this configuration of the parcel with 2 different zoning classifications, I think begs for the creativity that both the CDP and just, I think back to a comment that Justice Hand made in a decision in the Supreme Court that said the supremacy of reason should win out. And I think anything else.
He was never on the Board of Adjustment, I don't believe.
And I think even in his grave, he's probably thinking, thank God I wasn't.
He's really, really upset with you, I tell you.
So, well, now I'm going to quote from him anyways.
It's even worse, yeah.
Yeah. So the only thing I worry about is that making it conditional may give way to an excuse not to approve any site plan project. But I think of all the options that we have, a conditional variance makes the most sense. And I think we should be able to craft reasonable conditions to place on that portion of the parcel that, should be acceptable. And quite frankly, I think that, the majority of the people in town would probably be in favor of that. We need to get rid of the eyesore.
I don't know how you, some of the conditions that I would, if I was going to do a conditional variance, but I've never done one before, so I'm not exactly sure how you do it. Max is looking. Listen, you teach
it's a
the
rarity.
course,
It's
so-
a rarity, right? It's a rarity. And, to be fair, most of the time I would say you shouldn't do it. But if there's ever an instance you're going to do it, this one will work.
Well, I think especially because of the partitioning.
Does anyone want to try to make
I
a
would want
motion?
to see, would,
Can I offer some?
well, could I just ask you, a
Yeah.
couple of things first? All right, if you partition off these two lots, and I'm saying is,
Yep.
if they're off and they're going to be houses and you're going to try to sell them and make some money, then the property, those square footage cannot be included in
Correct.
your commercial.
They would not be able to
They
because
would
they
not
would they would be removed
Okay.
from the property.
All
So
right.
they would, if you can figure that out, I would love to
Okay.
do that, but
And I also think that, I was very sympathetic to the letter from the people at Scarborough Village about buffers. We used to, they definitely need some buffers and they need some protection from stormwater runoff. So I would want to see serious buffers between the Scarborough Village property and your property or.
and I don't have it in front of me, but I'm pretty sure the planning commission are going to require the buffers that are in the site plan between a commercial property. So you would make the condition that the buffering would be treated like this is a commercial property, meaning commercial up against residential.
Treated, I don't know, I don't have this letter in front of me.
The only way we could avoid the buffer would be as if we came to the planning commission and said, nope, we're R1 against R2, there's no buffer.
Does anyone have the letter from the people at Scarborough? I didn't print it. I printed lots of stuff.
I read it. I didn't
I
print
read
it.
it, but I didn't print it.
I can pull it.
But they were, thank you, Rick.
Asking
I
for
can't.
a new fence
Rick
and
has it, Rick has it here.
It's a very specific request, and I thought they were,
I can pull it up.
thanks, Rick.
Would you like me to read it to you?
if you, yeah.
So it was from a lady named Ann, or going to Ann, from Lynn and Suraba Sasrba.
No, I've got it right here.
Okay. So the fence between the property and Scarborough needs to be upgraded.
Right. Yeah.
The current fence is both inadequate and in bad shape, which I assume with a brand-new building would come brand-new fences in most cases. The landscaping between the subject property and Scarborough needs to be upgraded. The current landscaping is inadequate. I don't think they would have any objection to improving landscaping. And the drainage from the parking lot should be redirected away from Scarborough Village property line. Current drainage is inadequately controlled and creates problems in the community. The only argument I would have there is I believe Scarborough Avenue was built after this parking lot. So whoever designed Scarborough Avenue probably didn't take into account the drainage that was coming from the parking lot. So just a consideration.
You mean Scarborough Village?
Scarborough
Yeah,
Village was
yeah,
built
okay.
after the parking lot. So the hard thing with runoff is it's very hard to, when it's going one direction, it's very hard to pick it up and send it a different direction, especially when you have just a paved parking lot. But the parking lot was there before Scarborough Avenue, or Scarborough Apartments.
Scarborough Village, not before Scarborough.
Scarborough Village, yep.
Village.
Scarborough Village was there after the parking lot. So their drainage problem was created potentially by themselves. So I'm just putting that on the record.
Well,
that-
I don't think you can blame these people on creating a
No,
drainage
no.
problem from something. Scarborough Village has been there for eons.
Yeah, but the parking lot was there before.
I know.
Yeah.
I understand all that. But you can't blame the people now. They need to have this
Yes,
problem
correct.
fixed.
If we can fix it, I mean, but if the drainage is going there now, it's going to be very hard to say no drainage can go there in the future. So we can try certain things during the planning process and the design to, do it. And I hear you. I don't want to send, if they're getting flooded out, then we don't want to keep them flooded out if
Well, I
possible.
mean,
Can't you consider things like a retaining wall along that property that would sort of encapsulate the rainwater and everything on the parking lot, so it'd have to go someplace else?
If there's, and I do know the soils for the most part in town are very good, they're very sandy. So with a new design, you would be looking at certain things like infiltration, permeable asphalt, things that you could eliminate some runoff. And we'd have to go through a whole process of going to SCD and getting approval from them or acceptance. Now, I will say that when something's paved, it would be, I mean, I don't want to add more conditions, but taking this parking lot, we'd be pretty much allowed to repave this thing again if we were to redevelop.
Well, in actuality.
But we're actually making it
I
better.
didn't say pervious asphalt, did I? But I wish I should have. didn't
I know what you were thinking.
Because I'm a big believer in pervious.
All right, I'm gonna
But
ask.
but the residential portions which drain probably still, I mean, if they're getting runoff, it's probably going to drain from that parking lot. We're going to improve the situation by putting 2 residential houses here from a drainage standpoint as well. So,
I'm trying, yeah.
Bill's working on
All
it.
right,
but I think that's
all right.
more of a planning, zoning, these same people are going to come to those meetings and voice their opinions, and then the planning and zoning board would most likely require us to fix those issues at that stage. Not trying to take it off the table, I just think, I'm hearing you and I want to fix it, but.
All right, is anyone willing or wanting
I'm
to make
still
a
trying to-
motion?
I'm still
I
trying to
see
craft
2 people writing, so
Because this is too,
3
it's
people
too
writing.
much to just verbally do it.
if anyone wants
But Bill
to
probably
take a
does,
shot.
since he's got the
Well, I'm-
legal
I'm-
background.
Yeah, look, this is not a formal motion, but this is what I'm thinking.
Okay,
These are your thoughts.
The motion would be that in the event that the planning commission permits is it partition? Is that what we're talking about?
subdivision,
Subdivision?
Minor
Is it a subdivision or partition?
minor subdivision, yeah.
Minor subdivision, he said.
Could- Subdivision.
Minor subdivision or
okay.
subdivision?
Just subdivision.
Subdivision.
Okay,
Okay.
That makes it, yeah, that's the easiest way to put it.
okay. So where I was going was, the motion would be that in the event that the planning commission permits a subdivision of the applicant's property currently zoned as R1 into 2 or more R1 lots, I don't know if we want to say 3, but 2 or more, or maybe we want to say 3. Applicant may continue to maintain commercial parking lot on the remaining R1 zone lots. That's not perfect yet, but I think what we're saying is that, as I'm seeing it, if they are permitted to partition to 3 lots, and they want to make 2 of them into residential, they can continue with the parking on the remaining.
Well, why don't we say that? Something like,
She did say that.
Well, I couldn't, can I just jump in? If we were to state the conditions such that it specifically refers to if the subdivision is permitted, that the proposed 2 residential lots to the south of the remaining parcel R1, then you can use the remaining portion as parking.
I kind of had something like that, but, and this again, thoughts. Lots identified as number 1 and number 2 in R1 in the applicant's presentation. Because we've been talking all along for the last hour or whatever, 1 and 2. So we could say the applicant's presentation and the odd-shaped lot identified as lot number 3 may remain as a parking lot. Again, some kind of wording, I don't know how to do it, but
think we're all-
Bill had a great
I
start.
think we're starting the same.
But what's the condition then, the conditional use? That has to be approved by the planning commission?
Yeah, that, he started with that.
Oh, is that how you started?
Yeah.
Oh, okay, I missed that part.
That was his starting phrase, which I thought was good. But maybe the rest of you have a better thought. But it seems like we could just talk about because we've been talking about 1, 2, and 3 here, and we know what we're talking about. But if we say, as identified in the applicant's presentation,
Can I offer?
Maybe.
So 2 lots is really what fits. So I think we're fine with 2 lots. So if condition one is, should a just say subdivision of 2 lots or more, I'm fine with that, be allowed, the remainder, the residual land, the residual R1 lands on the property could be used as a parking lot. I'm fine with at-ground parking if that makes it even more.
Or could we say the remaining parcel of R1
Correct.
contiguous to the C1 designated property can continue to be used?
I somewhat offered these in the letter that I wrote, in the conclusion section. I basically put 3 caveats in here that I think are where we're trying to get. They just need to be reworded. And if I read those to you, it may help. Should the variance be granted and the property be redeveloped commercially, all other sections of the code not receiving a variance would apply to the entirety of the property. So that's a condition I put on myself, basically. Yeah. Should the variance be granted and the property is chosen to be subdivided, we're going to take chosen out and we're going to basically say must be subdivided. Any new property created in the R1 zoning with R1 zoning only would be required to comply with all code sections of the new property. So that means we're forcing that we can't, some of the questions that came up about could we have pavement, 40% pavement on an R1 property, that would eliminate that possibility. And then one thing we have to talk about with is how it should run with the property. And I think since we're gonna have to let it run with the deed, and as things are developed here, that portion of the property remaining would have this variance for future, lot fit outs and changes to the property, those kinds of things. Because if not, you could render this undevelopable in the future.
So we're going to only deal with the use variance today, is that correct? We're forgetting the area variances.
We are here for
That were requested.
that
So
is
we're
correct.
we'll need a motion to deny those at the end, right? If we're not going to, or do they become moot if the
Now, I
use-
think I agree with Edie, you have to state that in the motion, I believe. To cover all, because there's a request for
Well-
3, I think
Well,
we should
were- yeah,
address
One
3.
use in two areas.
Correct, we have to address
Yeah,
the-
we should
those
make it
3
clear
aspects.
that we didn't
Agree.
just not
Agree.
bother to look at them. Is that right?
Yes.
Yes. Would that be a separate motion, or what would you suggest? How would we handle that?
Now, tell me again, there's 2 area,
There-
and you're saying you want to just,
Yeah, the use is the main thing, because
and there's
really with
different
that,
standards, so it's hard to do, I would say, one motion with 2 different standards.
that's what I think. So the use is what we're really dealing with. And by not granting the use in full, I think the areas become moot. But I was just wondering how we should do that. So it's obvious we've done our business here today. We didn't drop the ball.
I think we just make a separate motion and explain like you did.
Mr. Chair,
So, yes,
may we take just a 2-3 minute break?
yes,
Because I need to think about, I want to confer.
okay.
I just don't want to make sure I just want to make sure we're all rowing with the same oar, and I apologize.
Before we make a motion, is that right?
Yes, if
Okay,
you wouldn't
that's
mind.
fine.
I'm sorry.
No,
It's
you
late.
don't have- no, we-
I was going to ask Max what he thought about
We are not on break, so please take a moment.
Yeah.
We come off.
You're good, Mr. Chair.
We're okay.
I'm
Okay.
very sorry.
Max?
I'm very sorry for the delay, but I wanted to make sure that the building inspector was on board with that was being proposed. For this, we think based upon sort of the plan sort of movement, you would have to make your decision on your use variance, and that would be conditional. We also believe that at this time, you would also make a conditional for a conditional area variance for lot, right, so it's 3, but it would be all conditional. The reason being is I understand it, and that's why I had a sidebar, correct me if I'm wrong, because then they couldn't modify, without that, they couldn't modify the parking lot. In other words, they would have to, even though it would be a conditional use, the second they moved it or touched it or removed it or reconfigured it, they would have to meet the lot area and coverage requirements within the code.
So how are
Did
you
I get that
suggesting
correct?
that-
Yes.
How are you suggesting, Max, that it be written?
So I think you came a long way, and I think many of the ways for a use variance, at least to take it to a vote and to go through those factors, I think you go ahead and make that motion, whether or not it's, building lots 1 and 2 or the rest, however that works. So I make a motion, you get that, and then you would go through, I think somebody would state the reasons in the record using the factors under, it's not Quick Check, it's Rehoboth Art League is the case. So you go through the Rehoboth Art League factors, and then you would take the 2 variances, a natural area and lot coverage, make it conditional the same way, but then go through your traditional Quick Check factors for that. You're my client. Did I get all that right?
That sounds correct. Sounds more legal
I can't-
procedure.
It's 6
This is a little.
I can't wait to
But it
hear.
doesn't matter. This makes me nervous now, because all of a sudden, we're granting wishes, it seems. I'm on board with the use, the way we were working for it before we took the break. I'm still on board with that. But all of a sudden, to also give blanket permissions without understanding the situation as it's going to be.
So you could do that. I mean, that's not going to make these guys happy, but that's okay. You could do that, but then you would have a future Board of Adjustment to come and hear just so you're aware, to hear the lot
Well,
area.
maybe we can, what's it called? It's a continuation? No, that's
No.
if you don't make a
Yeah.
decision.
No.
Our thought, I think, or some of us were thinking, to just deny or not hear currently the area variances, to figure out a way to give the use variance. I think, are we all kind of nodding about that in some way or somehow?
I'm waiting till I hear the
Thinking
motion.
The applicant might remove the request for area variance.
At this time, perhaps. And I don't know how everybody's thinking. I'm just saying, I was moving towards, very much towards, configuring a use variance with conditions that would let these applicants move forward in some form. But all of a sudden, giving the natural area and lot coverage as well, with no plan in front of us, no anything, that makes me feel uncomfortable.
I think what he's saying is that what we're proposing to do on the use variance isn't really adequate, because it would allow the parking lot to be there, but the parking lot then violates
Correct.
some of the
Area.
I understand.
rules. And so what we'll have done is doesn't yet let them move ahead, because they will be able to have the parking lot, but it can't be allowed because it violates the coverage rules.
And what is when you say conditioned upon the planning commission approving these things? Okay.
I think
Mr. Savage had his
So I
hand
think
up.
the easy way to put this is all 3 of them are together. And it's not that we want anything more for the lot coverage. So that could be contingent on the use, meaning the lot coverage and the lot area, those two area variances would only apply to this use. It wouldn't run with the property should the use fail. So you have to have it, because if we don't have it, you end up with a non-conforming parking lot that we have to be right back in here, assuming that the planning commission is acceptable of our subdivision. So it doesn't get us to where we need to get. I think we just end up back here anyway, which, you know, I don't think anybody, if we leave that parking lot, which is what this does, if we leave that portion of that as a parking lot until we redevelop, that's the end goal. And then we're gonna need this variance going forward, because being R1, we couldn't meet the R1 requirements and have a parking lot here. It wouldn't make any sense. So the use variance would not work without these other two area variances. And that's sort of where we are. I understand the hesitation, but by approving the use, you're essentially approving the area. It's just you didn't say it that way. But if you make it contingent upon the use and the use goes away, then the area variances also go away. We wouldn't be able to put a house here with 100% parking lot around it. It would have to go with the commercial, it would have to go with the parking lot use. We wouldn't be able to, we'd have to subdivide again to put another house, which would then be a whole other process. So I don't think there's no worry in my head that we could manipulate this in a way where the area variance oversees or overrules the use variance. The use variance is the big one, and you're there with that one. It's the area variances just are needed to basically make a formal variance work.
Can I, just to clarify, I'm getting a little bit confused now.
Thank you.
How? I don't know. Are you suggesting that you feel you still need the area variances even if the use variance is allowed?
Correct. So if the use can be a parking lot, now we can have a parking lot on the R1. But if the modification to the parking lot or building at that time, it would not allow the parking lot to exist in the same configuration it is now, which is what we would need. If we can't put a parking lot all pavement on residential. So all this does is allow the parking lot use to exist as it is, which is a good amount of the property. But if you were to try to make that parking lot conform to an R1 district, we've all talked about it, and it would be a fraction of the property would be able to be paved. So you wouldn't have a parking lot then. So,
If we were to say something like, provided the planning commission approves a subdivision of that portion of parcel number zone R1 into 2 or more lots zoned R1, the subdivided lot that is contiguous to the portion of the parcel zoned as C1 may continue to be used for parking.
correct.
Does that not accomplish what you want? And then we might impose some additional
Correct. I think that's,
conditions.
yeah, and then you put the conditions on and just maybe acknowledge the fact that to be a parking lot, the area variances are needed to allow it to remain, basically. So you're pretty much saying, I'm okay with it, I just don't want the planning commission to then come back and say, we gotta take the pavement back down to 40% lot coverage, which would make no sense.
So it might be best to do a separate motion and make the area variance request contingent upon
Correct.
the use variance.
Yeah.
And then examine them separately, the two different standards as well. But the area variances would be contingent upon the use variance. So if the use variance goes away, the area variances goes away as well. I'm sorry, I'm not talking into this. Sorry about that. I think a smart way to look at it might be to
You better talk into it, because he'll get really pissed.
is to make the area variance request contingent upon the use variance. So if the use variance goes away or fails in front of another board, the area variance also goes away or is unenforceable, is no longer valid, I guess I should say.
Correct. That is acceptable to us.
Would have to be in more than one step, more than one vote with two different standards that we'd have to analyze as well.
So you're suggesting we first vote on granting the area variances? No, I thought you said we have to first do the area variance.
The use
Subject
first.
to the use.
No, use variance
Okay.
first and then.
Okay, whatever.
Yeah, which is what you had, Rick, and yours is the use. It can be.
Mine was the use.
It can be a parking lot, and then we would need a separate one that says, you know,
Area.
the use variance previously approved, if that's what we did, is further subject to, you know, variances with respect to the area requirements and whatever the two provisions are. But, because they're approved under different rules, under different standards, actually.
But, you know, I mean, I'm not against all this, but I'm sitting here thinking about, what if these folks are just totally done after 4 or 5 years of this, and they decide, okay, we're just selling the whole property, we don't care. What do they have?
Well,
What, that's what I'm trying to get to, is
But
that.
this is all contingent on approval by the planning commission
Right.
of a subdivision.
I'm going to, usually the chair does not make a motion, but I'm going to flip this 180 degrees. I want to consider a motion to deny, based on the needing to make the property compliant for a possible subdivision of R1 properties. And then if the building inspector requires a variance for the C1 portion to delay reconstruction of the property, then they seek the variance to come back to the Board of Adjustment and say, I need a variance to say, hold on the C1 portion until I can redevelop it. I mean, that's a 180-degree flip to say, get the property. Again, it's crazy why it's a split zone, the troubles that it's causing us is to just get the R1s back to being acceptable R1s, and it may require repaving, cleaning it all up, and then coming back to the Board of Adjustment to say, hey, look, I need a variance to not, if Corey says you got to take the whole C1 building down, get a variance on that, and then come back and asking, can I get a coverage on that odd-shaped lot? Because I do think the Planning Commission is going to look very favorably on a mixed use. I mean, I think the end results, we all want to get there, a mixed use, allow adequate parking to that, and that crazy lot 3, or maybe even asking the Planning Commission, can you give me an exception on lot number 3 and make that piece commercial, and get it back to 2 R1s and a larger commercial than it is right now, but not the original very large one. I mean, that's kind of, I hate to throw this in at you guys at the end, but I'm like Edie. I'm getting twisted around here, and I just think the intentions are good.
Yeah.
Great idea, but I just think we got to get through the Planning Commission first, and you got to make it acceptable for them to come back here.
Yeah, I think it, I guess what I'm hearing looking at the board here is I think we're all on the same page that if we can get that plan done, which is where we're trying to go,
Right.
the variance makes sense. The variance we're asking for is a use variance to leave a parking lot. We added these other 2 area conditions in here, in my opinion, to make that use legal. Because if you pass the one use, which is where we are, somebody in this period of time can then say, like, I don't think you're going to get buy-in to redevelop the property with a like we can't tear it out, subdivide it, and then have the possibility of a next variance not passing, because then we end up rendering the property undevelopable again, and we're sitting here having the same argument. Personally, I don't see, if you're allowing the parking lot to exist, I don't see an issue with the two area variances, because they are contingent on the first variance anyway. So we can't ever do anything. All we're doing is leaving that there for a short period of time, and you're approving it to allow it to stay there until it gets redeveloped. When it gets redeveloped, planning and zoning could make all kinds of conditions on this property. We just need some reassurance that it can stay as a parking lot, because without that, we can't even draw plan number 1. We would be in there, You know, and I think we would get very far down the road, which is the worst part. We get very far down the road, and then we get stuck at a stopping point of that can't be a parking lot, or we get other complaints, different homeowners. So I think if we're going to make a decision, I think that I like it wrapped into one, so it's all one variance, and the two areas are just a side effect of the first use. But that's my opinion.
I think it's like a 6:15, folks. And I would say that, I'm sorry, I'm telling you, I would say that we have 4 lawyers here. And between you, I think you could come up with something that will get us out of here at a reasonable time, which we've already passed that, and also do what we want to do. I'm not a lawyer. I wouldn't even try. This has gotten so confusing to me. I mean, I know where we're going. How do we get there in a reasonable amount of time? And, as long as the Planning Commission has approval, I'm fine, because they'll put in the buffers. They'll put in those things that we think are important for the neighbors and for the property. But how do we word what we want them to do? So I would look to Rick. Is it Diane? Yes. Bill, Max, anybody?
So,
Well, Corey's got his hand up.
If I could,
Of course.
I want to parrot the fact that I was in agreement too, that I had, when we were discussing this natural area and lot coverage as a side effect of the use. Just to cover all the bases, really. The meat of it was the use.
Right.
And Rick, I think when I listened to what you had so far, it sounded great. I would just maybe to include one last thing at the tail end of it that could help cover this, read exactly what you had read before, and then just include something similar to under it or with the under the existing configuration or existing dimensions as portrayed in applicant's exhibit, because what you read there was perfect. And then if you throw in at the tail end of it as a caveat that encapsulates either dimensionally or configuration, some kind of geometry of how it looks like that right now, that would encompass the use, and that variance would run with how it looks now. So we're not. It's not like they could create a larger parking lot, not that they could, because it's right to the property lines anyways, but as it looks right now, as far as dimensionally and how it's shaped, I mean, it goes to the ends, that might help. Is what you're suggesting something to the effect that the remaining portion of the R1, or the remaining portion of the parcel designated R1 after the subdivision that is not a rectangle and contiguous to the existing C1 is, basically the area that we would be granting approval of the use variance. Is that what you were looking for? Rick, did you write down what you had read about
Can you put a diagram in there to show what you're talking about?
10 or 15 minutes ago?
He has this here. He has it all here.
What I said was, provided the Planning Commission approves a subdivision of that portion of parcel, whatever it is, zoned R1 into 2 or more lots zoned R1, the subdivided lot that is contiguous to the portion of the parcel zoned C1 may continue to be used for parking subject to the following conditions. I suppose we could say the subdivided lot that is.
Isn't it the remaining portion?
The remaining.
The remaining contiguous portions.
They're all remaining portions.
But he says 2 or more lots.
Yeah, 2 or more lot.
So if it was 2 lots, there might not be remaining, but.
Yeah.
Okay.
But you're the lawyer.
But to me, the subdivided lot that is contiguous to the portion of the parcel zoned as C1 should make it clear which portion of the subdivided property we're talking about. Do you agree, Corey? That I agree. And then I think under the conditions, you could state
either by the dimensions.
How about if we
portrayed.
say the subdivided lot that is contiguous to the portion of the parcel zoned as C1, and then put in parentheses, i.e., the portion that is an irregular shape.
Yes,
And contiguous.
It's called out.
Contiguous is the key word.
Contiguous, isn't it?
Yeah.
The residual R1 zoned portion of the property that is contiguous with the C1 portion of the property.
Yeah,
think
well,
he
that's,
was
that's what
fine
I originally said.
So you ought to make that motion.
We
Well,
haven't
well,
figured out if
we-
there's anything else
we
that
haven't-
needs to hang on the tail.
Well, the tail is whether or not we want to, on the grant of the use, to add conditions such as upgrading fencing, things of that nature. But if I understood Jan correctly, we leave that to the planning commission to
Well,
handle.
I don't know, am I correct in that the planning commission will do this?
Well, it's what the planning commission is supposed to do.
Well, yes, we know, yeah,
I mean, you and I both served on the planning commission.
yeah.
That would be in their purview for certainly.
Okay, all right.
Then-
And I
then-
think if they listen to the conversation, then they'll know.
So I think we take off what I said about subject to the following conditions, and then it's a very short motion for the use variance.
Can you read it again, please?
Yes. Motion, well, I still won't say motion now until you tell me it's okay. Provided the planning commission approves a subdivision of that portion of parcel, I'll have to insert the
Yeah,
number,
that's okay, you'll get the number.
R1 into 2 or more lots zoned R1, the subdivided lot that is contiguous to the portion of the parcel zoned as C1 may continue to be used for parking.
That seems right.
Sort of, I think it's short and to the point.
That seems,
Can I ask, do you think we ought to put some of the conditions on about landscaping, fencing and stuff, or leave that to the planning?
I say no.
Yeah,
This is
I think that's
complicated
planning
enough.
commission
Okay,
stuff.
all right.
To
Don't
begin.
Their
say
purview.
anything on
Okay,
this.
well,
They will get the message from us.
Can I get a second
To-
on that
Hold on,
motion?
hold on, there wasn't a motion, there wasn't a motion. He didn't actually start a motion. He's got to read it one more time.
beg your pardon?
There wasn't a motion, you didn't,
Yeah, I know.
and,
Okay.
and would you state?
Say it
would you
again
put
as
at
a
the
motion.
beginning, grant of the use variance?
Yes.
And don't, yeah, when it's time to vote, don't forget about the criteria.
Okay. I move that, well, the motion is to grant the use variance requested by the applicant with respect to 330 Rehoboth Avenue, provided the planning commission approves a subdivision of that portion of parcel tax map 334-14.17-139.00 zoned R1 into 2 or more lots zoned R1. The subdivided lot that is contiguous to the portion of the parcel zoned as C1 may continue to be used for parking.
May I get a second on that motion?
I'll second.
Okay.
Okay. Now, I'm going to start with you, Bill, on your reasoning for voting to approve or deny this motion.
I would support the motion. I believe that the applicant has made the case with respect to the required findings as to merit a use variance, and that, period. The question I have is whether we need to, I guess we will address separately the area variance. So I'm only addressing the use variance.
This is for the use, yeah.
Because it has different criteria. Or similar, but different.
Or do you adopt the reasoning set forth by the developer as part of your reasoning?
Four
Do
criteria.
we?
Yeah, the criteria.
Four criteria.
Yeah, why don't we set out what the criteria are so that we all have them, because they do vary from the,
I'll just read them aloud. Number 1 is the property cannot yield a reasonable return when used for a permitted purpose. Number 2, the need for the variance is due to unique circumstances and not general conditions of the neighborhood. Number 3, the use will not alter the essential character of the locality. And number 4, all uses of the land permitted under existing zoning regulations are economically unfeasible.
yeah, I guess I would add that I believe that the applicant has established the required showing with respect to the need for the variance as to the ability to obtain a reasonable return, that the proposed use does not affect the character of the neighborhood, that they're not altering the, I forget what the third.
Altering the character, and then the
Yeah,
economically.
And that without the variance, it would be, the property is not economically feasible. Development of the property is not economically feasible.
All right, thanks, Bill. Jan?
I vote yes for the same reasons that Bill mentioned.
Oh, you had a much easier time.
Well, no, listen, I coached you for the last one.
Edie?
Sure. I vote yes as well. I think that the property can't yield a reasonable return in its current configuration. There are very unique circumstances with the C1, R1, and the shape and lay of the lot. It doesn't really change it will actually improve the essential character of the locality in a good way. And all uses of the land permitted under existing zoning are economically unfeasible with the current configuration without subdivision. So I think that it's the way forward.
Rick?
I vote in favor. I too believe that all of the standards for a use variance have been met in this case, particularly given the rather unique nature of the split-zoned parcel, which I believe needs to be considered as a whole and not based upon only zoning portions of the property. And given that, I do not believe that the property cannot yield a reasonable return and only for its permitted use. And the need for the variance is really due to unique circumstances, as I just mentioned. And I think that it's an enhancement of the character of the locality rather than any kind of detrimental use. And given, again, the nature of this oddly zoned property, I think that under the existing zoning, the uses are economically unfeasible.
Thank you. And I am going to vote no on the motion. I still think the proper procedure would have been to get the lots back to residential quality, if I can call it that, and then ask the planning commission to turn the odd-shaped lot into commercial. And then you would have ended up having a residential 1, residential 2, and then a commercial lot. And then if variances were needed as a result of that, then come back to the Board of Adjustment for that. So I am voting no, but the motion carries 4-1. good luck. I think we all agree something has to be done with that property, and, you know, I wish you luck at the planning commission in getting that through, so. Oh, that's right.
You're not going home.
So one's done, two more to go.
maybe not the road.
By the time we're done, Summer House
Marco ordered
Monday
dinner.
is
Bloody
done.
burger
It's
night
going to
or
be over.
whatever.
It won't be
Probably doing both at the
Burger
same
Monday anymore. Sorry.
It'll be midnight Tuesday.
Taco Tuesday.
Is that called hangry? All right, let's get a motion.
Well, can the motion be to deny the area variances because they're, or what, I mean, what is the motion? I don't know
No,
where
he
that.
Someone has to
he
make-
still needs them.
Can I read what's in here? Because I think it's going to make sense when you look at it this way. Now that we know the use can stay, now we need a motion to basically provide relief specifically to allow less than 50% of the gross lot and less than 50% of the front yard setback to be natural area for parking only.
But we already said that that one lot would be parking.
Correct, but
So why do
it
we
doesn't
need
give you
this?
relief from the
He
fact.
needs the relief
It
for
can be
the
parking,
odd-shaped
otherwise
lot.
they're
It's
gonna
still
half
gonna
lot.
be, still gonna be zoned R1.
It's still zoned R1, so we're allowing the use,
All right,
but we need the
okay.
relief from
But
the,
this only is for the, the weird lot.
correct.
Lot three.
Lot 3, correct.
It'd be one motion to address the lot
Both of
coverage,
them.
yes.
But what's the correct phraseology then?
Again, if you look here, I think it's here. So it should be relief to allow less than 50% of the gross lot and less than 50% of the front yard setback to be natural area only for parking only. Also, we would specifically need relief to allow more than 40% of the gross lot area for lot coverage for parking only. And this would all be contingent upon the use remaining as parking, the variance that we just approved. So those two area variances would run with the variance that we just got for use only.
So the variance being requested is simply relief from the minimum natural areas
Correct.
set forth in section 270-21 and
Yes.
from the lot coverage.
Maximum lot.
Lot coverage. And from the maximum lot coverage pursuant to 270-21.
Correct.
Right, okay.
And this motion should be contingent upon
Planning Commission.
the, well, the use.
Contingent upon the,
The use
no,
variance. Or the use, I'm sorry, the use.
isn't the
that
use
persists.
contingent upon these,
No,
No.
the other way? Okay.
these won't even be looked at if the use is knocked down. Or if the planning commission doesn't
Okay,
agree
so-
with our use.
So then our motion is going to be along the lines of to approve the requested variances from minimum natural area pursuant to section 270-21 and maximum lot coverage pursuant to section 270-21A lot coverage.
C is lot coverage. A is natural area, I think, isn't it?
No,
Have I got it reversed?
well, there seems, okay, I see where you're looking, and that's over here.
C is lot coverage, A is natural area.
Yeah, C is lot coverage, A is natural area.
Okay.
I'm sorry, I interrupted you, Rick, excuse me. You were on a roll there, and I
That's
think I
okay.
screwed you up. I'm sorry.
R1 is natural and C, okay. Let me go back and restate this.
Are you making a motion
I can
now?
make,
or-
I can make a motion now.
Okay,
I move that the area variance requests by the applicant be granted and the relief from maximum lot coverage pursuant to section 270-21C lot coverage and the maximum
No, minimum is natural area.
Yeah, and the minimum natural area required by 270-21A are granted
Contingent upon.
contingent upon the previous grant of the use variance for the subject property remains effective.
Is that crisp enough? Doesn't quite, it's great, but it doesn't seem crisp enough to me. Wording. You've got it all.
Just add the words, such that if the planning commission does not make the required approval, the variance will be null and void.
Thank you, that's a
Thank
good
you.
idea.
I'll accept that as an amendment to my motion.
Do we have it all written down now? That's always the thing with Ann, too.
No, but Marco has it, right?
Can we just restate it?
Yeah, see, that's the problem.
No,
That's the, that's the problem, if we don't write it down.
Go through yours and I'll add to the end.
Okay,
Then
Max,
somebody better
just-
call out
just-
and get hamburgers or
Just stop me
something.
where you want me to insert your language.
Don't we say
Just get
that
to the end and I'll add mine to the end.
we,
Okay, okay.
we move to grant relief from a maximum lot coverage, 270-21C, and minimum natural area, 270-21A, contingent upon. That's as much as I got written, and then I was,
Contingent
Contingent
upon.
upon the planning commission
Approving the subdivision approving the subdivision here and before discussed.
or, yes, that works for me.
You forgot to say it was only for the contingent lot, not for
Right.
lots 1 or 2.
This, and then add to the motion, this is only for Lot 3. Lot 3, the
I
contingent
don't
area
think we can
closest
say
to the
lot
commercial.
3 because it's labeled lot 1.
okay,
Yeah.
let's go back.
On the piece of
Let's
land
go
that
back and
was-
get this right.
Yep.
If
The motion is great, Rick's great start. Grant relief from maximum lot coverage, section 270-21C, and minimum natural area, 271-21A, contingent upon the planning commission approving the subdivision herein.
Well, can't we say the subdivision of the R1 portion?
Okay, that's
of the
good.
parcel,
The R1 portion, I'm writing this down so we can
Okay.
make sure Marco has it too. R1 portion,
Associated
parcel.
with the use variance.
I'm sorry,
Associated with the use variance.
associated, applicable to the use variance granted immediately prior to this motion.
is that, do you have that kind of thing, or are these so separate that they're
Oh, I
not
thought
going to
it
be
was-
looked at, right, one after the other?
I think we should tie it to the first.
Oh, I think
To
we
the
should
first
too.
one, and if the first one's not approved, the second one's null and void,
Okay,
isn't that what you said?
So
Ben?
let's get the final wording. Contingent upon the planning commission approving the subdivision of the R1 portion
Of the parcel,
of
the subject parcel.
the subject parcel.
Right, we could insert the number that I
Applicable to
have.
the motion, applicable to the use variance.
Okay, of the subject parcel,
Applicable
we can change this now, I'm just making it applicable to
the use
The use
variance.
the use variance. Now, we want to make sure that it's only for the, what we call Lot 3, right? Not
It's
lots
the-
1 and
it's-
2.
Use
it's
the words,
remaining- I think we should use the same language we did in the first.
the contiguous lot, I think you used.
Partial
And
2.
Bill's been writing also.
I haven't.
Oh, you haven't?
Am I the only one writing?
Maybe that kind of explains it. That applies to the use variance, i.e. the contiguous portion.
Okay. Of the
it's null
subject
and void
parcel
if it
applicable
doesn't
to the
pass.
use variance
You say-
Granted with respect to
granted,
that portion of the R1
granted to that.
parcel, that
Portion.
portion of the parcel zoned R1.
But you only
is-
wanted
That
the
is,
far
that
one.
that is, I haven't finished,
Oh, so I'm sorry, I'm sorry.
that is contiguous to the portion of the parcel zoned as C1.
C1.
Okay, then I'll read it again, just a sec.
Yeah.
All right, here's what I have if I, if
So
I.
let me ask you, may I have a motion on the area variance? That's your lead in.
Okay. No, but Rick should get credit. Rick did it all. All I did was scribble.
Okay.
The scrivener. Okay,
Make the motion for me.
I'll try.
I'll second. your-
Okay.
Why don't you make the motion?
Well,
I'll
make
second.
sure it's right first.
Yeah, well,
I move that we grant relief from maximum lot coverage, section 270-21-21C, and minimum natural area, 270-21A, contingent upon the Planning Commission approving the subdivision of the R1 portion of the subject parcel applicable to the use variance granted.
previously granted.
Oh, previously, okay, I missed a word, I'm sorry. Previously granted,
Or, no, take out previously, I think. It should be granted immediately prior to this motion.
okay, and then we still have more words after that,
Oh,
because we have the portion of the parcel zone R1 contiguous to C1. We still don't have this end part right yet.
Well, we're just kind of explaining what portion of the parcel we're describing.
Exactly. Okay. Maybe we need two sentences.
well,
Grant relief from the maximum lot, blah, 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 contingent upon the Planning Commission approving the subdivision of the R1 portion of the subject parcel applicable to the use variance granted.
in the immediately preceding motion.
Okay,
And then you could say i.e.
just a minute. In the
Immediately preceding motion.
immediately preceding motion,
Parents, i.e.
i.e.,
the grant of use variance. Close parents,
i.e. what?
i.e. grant of use variance, of related use variance. Why don't we do it that way? Close parents.
I want you to say, period, this area variance.
See, that's what I wanted to make a separate sentence.
Is,
Getting way long.
It's getting long.
no, but it's in a sense.
Yes,
Yeah, this use variance applies only with respect to
good, good,
that
good.
portion.
This use variance.
Well, this is an area variance.
Area.
I'm sorry.
Oh, this area,
variance.
right,
This area variance
Applies
applies only with
only
respect to.
to,
With respect to the
Go back
use
to that.
variance.
only with respect
That
to
portion of the language that Rick was
Yeah,
using.
that portion
portion.
of
Okay, you're good,
of
Rick.
parcel 334-14.
I'll write that in a minute. I'll put it in a minute.
Zoned R1
Zone R1,
that is contiguous to the portion of the parcel zoned as C1.
Do you want to amend your motion or start from the top? Because I think we just got wordy and we're just trying to kind of describe the portion of the property we want this
I think-
variance
but
to
I
Don't
apply
we want
to.
to say it's null and void if the first one doesn't pass?
well, if it's never seconded,
It's contingent upon.
Okay.
okay, okay, let me make sure we have this right. Grant relief from max block, blah, 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 contingent upon the Planning Commission approving the subdivision of the R1 portion of the subject parcel applicable to the use variance granted in the immediately preceding motion. Right, period, then, right? Right, Bill? Okay, and then this area variance applies only with respect, just a minute, to that portion of parcel number, I'll put the number in a minute, zoned R1 that is contiguous to the parcel zoned as C1. Is that cleaned up?
That's correct.
Okay.
I mean, I guess another way to just make it even smaller would just, you know, we kind of explained this portion we're trying to get at in the use variance, so we could have just adopted it, but maybe we got there, and if you guys want to just move forward. I mean, we got there in the first one, but I think we're far enough along, let's just keep going.
What, I don't know what you mean.
Go ahead, and if you're ready for your motion, I think we've got there now.
Well, I don't know. Are you guys all ready for a motion?
Ready?
Okay. All right, I move that we grant relief from oh, wait, I need to put the parcel number in here so I can read it. I don't have it in front of me.
It's right here.
Okay, number. Then I can read it better if it's right here instead of .17-139.00. Just leave that there then for a second. Okay. I move that we grant relief from the maximum lot coverage, section 270-21C, and minimum natural area, section 270-21A, contingent upon the Planning Commission's approval of the subdivision of the R1 portion of the subject parcel applicable to the use variance in the immediately preceding motion. Then this area variance applies only with respect to that portion of parcel number 334-14-17-139.00, zoned R1, that is contiguous to the parcel zoned as C1. Is that
I second.
everybody okay? You firsted. You were the guy who started all this.
All right, Rick, I'm going to start with you.
And don't forget to use the quick check factors here
Yeah,
for the
yeah,
area
I'm not.
variance.
Let me just grab those. You're starting with me?
Rick.
Oh,
Rick, please.
Oh, Rick, great,
Oh,
okay.
wonderful.
Rick, great.
Okay, that's all right, I can read through that.
You have yours out.
Yeah, I do. They're right here. Certainly.
I vote in favor of the motion because I believe that all of the factors of quick check have been met. I believe that the relief requested is appropriate, that it is consistent with the character and uses of the immediate vicinity. And that the variance does not pose a serious impact on neighboring properties. And that if we did not remove the restrictions, they would create an exceptional practical difficulty for the owner of the parcel as a whole. And on that basis and the unique nature of this particular parcel, as I said, I vote in favor.
Okay, thanks, Rick. Edie?
Sure. I vote in favor too, dittoing what Rick said. The zone where the property lies is certainly acceptable for this use. The same with immediate vicinity. If we remove the restriction, we're not seriously affecting the neighboring properties because there's been a parking lot there for 40-plus years. And I believe that there would be, there's an exceptional practical difficulty in that the applicant cannot move forward off the dime without this combination of our use variance combined with this very specific area variance to make the use variance practical for them to use.
Thank you, Edie. Jan?
I also vote yes, and I believe that it's not economically feasible to do anything else at this point, and it's not going to change the character of the neighborhood except in a positive way, and I support everybody else's rationale too.
Do you
Thank
adopt
you.
it as your own? Do you adopt the other rationale you've heard as your own?
Yeah, I just said that, didn't I?
Okay. I was just tightening the language a
Oh,
little bit.
tighten the language. Thank you, Max.
All right, and Bill?
I support the motion. I believe each of the quick check factors has been met with respect to the nature of the property, the character of the immediate neighborhood, the impact on the neighborhood if the restriction is not removed, and particularly the exceptional practical difficulty that the owner faces given the testimony that has gone on today.
Thank you, Bill. And I am going to vote no. The nature of the zone where the property lies, granting the coverage for what is an R1, I think the correct procedure should have been to restore it to R1 and then seek variant, go to the planning commission, get that, as I said before, and then come back for other variances as needed. So because it cannot meet quick check factor number 1, I'm voting no. The other 3 quick check factors I'm okay with. The uses of the immediate vicinity, and I don't think there's any other implications of approving this because there was nothing like this in the city. And for, there are other alternatives for the owner if they were to choose, so choose. So I am voting no, but as we said, this is a 4-1. This passes, and we might be seeing you again here for other variances. So everyone, thank you for sticking with us. Marco, are we going to be meeting in July? Do you know?
Are there
I
cases?
will talk to the city secretary, and I'm sure she'll be reaching out.
Okay.
We'll get you an opinion within 30 days.
I'd just like to say, this is probably my last time. It's been a pleasure to appear before this board. I
Thank you,
really
Max.
enjoy you guys. You guys
Thank you,
do a
Max.
really nice job and are very considerate, and I've enjoyed my time here in front of you. Maybe I'll be back someday. And thank you to Diana, who I brought in.
Thank you, and congratulations on that. All right, thank